Welcome, everyone. The Foul Play YouTube channel, open mic number 184. I did a little rearranging with some numbers here, but I apologize for being late. StreamYard gave me a fit trying to get this scheduled, but finally got it to work. Anyway, KZ has filed her brief, and for those that haven't seen it, it's 57 pages in total, so probably around 55 pages, I'm guessing, total, somewhere around there, 54, 55. So, we're going to go through this and read it. I have not. I don't know if Susan or anyone has. It's been out for a little while now. Susan, have you read through some of this?
Just a small bit of it.
Okay.
No.
Well,
I think Duke has read some of it as well.
Duke, have you read some of it?
Yeah, I've read some, but I mean, it's only been out for, we got that notification around noon, but it actually didn't get filed because it was filed incorrectly the first time. So it didn't come out till about 4 Central here. So it's only been out about an hour. Got a little bit read, but not too much, about 15 pages of it.
Okay. Well, I guess we'll find out together.
Yep.
So unless anyone has something to say before we get started, I'm going to throw this up on screen. Doc, you got anything?
No. The only little thing is to plug in our new podcast series starting tomorrow, Reading with the Crew.
Oh yeah, absolutely.
Unbelievably, talk about timing.
Yep.
Perfect timing.
It is really, and I think that's going to be interesting. That's all I'm going to say. Alrighty. All right, let me get this on screen here. Okay. All right. We had somebody fall out and come back, it looks like. Who fell out? Oh, it was Cherie that fell out. There you go, Cherie. All right. Let me see here. Susan, you feel up to reading for a spell?
Sure.
Okay. You read whatever you feel like reading. And I'm not saying we're going to read straight through it, but we'll read whatever and maybe take a little pause so we're not just straight reading. Discuss anything of interest. Guys, please stop us. Please just stop and certainly in the live chat, if there's questions as we go through, just put them in there. I'll try to highlight them as we go, and we can get to them. Alrighty, Susan. I'm going to scroll down here, and you can start whenever you are ready.
Okay. State of Wisconsin versus Stephen A. Avery on appeal from the order denying post-conviction relief entered on August 22nd, 2023 in the Circuit Court of Manitowoc County, case number 2005 CF 000381. The Honorable Angela W. Sakevich, presiding judge. Issues presented. 1. Whether this court must conduct a de novo review of the sufficiency of Mr. Avery's motion for post-conviction relief on its face because of the circuit court's failure to conduct any such analysis as a matter of law. I'm hearing an echo from someone. The circuit court answered. No?
Okay. I'm not getting an echo. Mm-mm.
The circuit court answered no. Number 2, whether the circuit court improperly imposed a burden on Mr. Avery to conclusively prove the Denny motive element in order to satisfy the materiality prongs of State v. Edmonds and Brady v. Maryland. The circuit court answered no. Number 3, whether the circuit court erred when it did not correctly apply State v. Denny to Mr. Avery's potential third-party suspect evidence? The Circuit Court answered no. Statement on oral argument and publication. Pursuant to Wisconsin Statute 809.22, 2022, appellant requests oral argument to facilitate review of the complex legal issues raised herein. A publication is warranted because the case is of interest to the public. Introduction. When dealing with stakes as high as a defendant's liberty, third-party perpetrator evidence walks a bit of a tightrope. State v. Mull. Without regard for Mr. Avery's liberty, even after he has brought forth strong new evidence connecting a third party to Ms. Halbach's murder, the Circuit Court has denied Mr. Avery the opportunity for an evidentiary hearing. Mr. Avery now appeals the Circuit Court's denial of his amended third post-conviction motion because the Circuit Court's opinion is so legally and factually flawed that it does not even consider whether Mr. Avery has alleged sufficient facts to warrant an evidentiary hearing. Instead, the Circuit Court erroneously interprets State v. Denny as requiring conclusive proof of motive to satisfy the materiality requirement of State v. Edmonds, and as requiring the alleged third-party suspect to have the quote-unquote necessary skills to manipulate evidence in a manner that would implicate the defendant to satisfy the opportunity prong of Denny. The Circuit Court's decision denying Mr. Avery an evidentiary hearing on his new evidence of Bobby's possession of Ms. Halbach's vehicle is based on an irrational premise, quote, that Bobby could have been in possession of the car that night to help hide evidence to protect the two individuals directly linked by forensic evidence to this murder and convicted of the crime, end quote. Let's see, there's a footnote here. Citations to the record on, okay. Citations to the record on appeal appear with the document number before the colon and the page number after the colon. A citation, for instance, refers this court to page 16 of document 429. Citations to different documents in the record are separated by semicolons. Where available, parallel citations to the separate appendix appear in separate parentheticals after the citations to the record. Mr. Avery shall cite to the concurrently filed separate appendix as, quote, app. Page numbers. Okay. Let's just see. First, the Circuit Court is hugely mistaken in presupposing that Brendan Dassey was ever linked forensically to the crime. He was not. Second, the Circuit Court erroneously relies upon evidence that was barred from being considered at Mr. Avery's trial, such as Brendan Dassey's quote-unquote confession, to support its decision to deny Mr. Avery an evidentiary hearing. I'll go to the second, what's it called?
Footnote, 6-second footnote.
Thank you.
Oh, that's a long one. Jeez. Wow.
Yeah, it is. On June 6, 2007, in a letter attached to Mr. Avery's PSI report, Judge Patrick Willis evaluated the reliability of Brendan Dassey's quote-unquote confession as follows, quote, Brendan Dassey did not satisfy at the trial in this case. The jury was not required to assess the credibility of any statements attributed to him, end quote. Quote, charges of first-degree sexual assault and kidnapping which were added to the information after the police interviewed Mr. Dassey, were dismissed by the state before trial, end quote. Quote, the account attributed to Mr. Dassey in the PSI is based on one of his interviews with police. He was interviewed by the police on other occasions during which he gave somewhat different accounts of what happened. He also, at some point, recanted his statements admitting involvement in the crimes, end quote. Quote, the physical and forensic evidence introduced at Mr. Avery's trial failed to provide corroborating support for a number of the allegations attributed to Mr. Dassey. As one significant example, there was no physical or scientific evidence demonstrating that Teresa Halbach was ever present in Mr. Avery's trailer, end quote. And, quote, an expert witness called on behalf of Mr. Avery at his trial, one Dr. Gordon, and a Dr. White, retained by Avery's counsel, both called into question much of the information provided by Brendan Dassey because of his intellectual limitations, his susceptibility to suggested answers, and the nature of the investigative techniques used, end quote.
Wow.
Yeah. The circuit court's speculation is that when Bobby moved Ms. Halbach's vehicle onto the Avery property, it was his intent to help his uncle by hiding evidence. This is contradicted by the fact that all of the forensic evidence used to convict Mr. Avery was in the vehicle and was discovered because the vehicle had been moved onto the Avery property. Mr. Avery's blood and DNA was in the vehicle. Ms. Halbach's electronic devices from her vehicle were subsequently found in Mr. Avery's burn barrel, and the RAV4 key was later found in Mr. Avery's bedroom. None of this incriminating evidence was discovered until the vehicle was brought back to the Avery salvage yard by Bobby. In the circuit court's nonsensical conclusion, because these actions could be seen as an effort by Bobby to help Mr. Avery, he cannot be considered a valid third-party Denny suspect. The circuit court failed to explain why, if Bobby was simply lending a helping hand to his homicidal uncle, he would then become the state's star witness against Mr. Avery.
Damn.
That's an awesome statement right there.
Anybody want to pause right here for a second? Because that's a hell of a little statement there she made. Anybody? Doc? Dude?
No doubt. Makes perfect sense to me.
Well, yeah, because the way that I think she's right. The way Suckowitz went about, because we were all incredulous. Remember reading us going through her response, and it was like, wait, what? She doesn't care that he potentially has her keys, he has her car. Come on, it doesn't matter.
Simply lending a helping hand
to
his homicidal uncle.
Right.
Well, I mean,
Doc?
This is the whole basis of what we're going to be reading in the chapter in tomorrow's podcast, or commencing the podcast tomorrow. Judge Suckowitz is basically walking on eggshells here. If the state are prepared to accept, now remember, we're not blaming Bobby Dassey for anything, but if the state is prepared to accept that Bobby Dassey was in possession of Teresa Halbach's vehicle, they now have to come up with some type of suggestion or suggestions as to why Bobby is in possession of Teresa Halbach's vehicle. And look, you're really walking on very thin eggshells if you think that it's because Bobby Dassey was trying to help Stephen, right? You're gonna end up in a land of a lot of hurt if the judge is going to go on this way, because Kathleen Zellner will absolutely destroy this type of premise. Yeah, it's not looking too good.
Yeah. Yeah, this is going to be, in my opinion, probably the first of a lot of different mic drop moments for KZ in here. And, as I started to read this myself, that statement in general, I couldn't help but remember that Judge Suckowitz has removed herself from this case now. And I don't know, part of me thinks she's getting out of the way because she knew what was coming. I mean, this is going to be an absolute ripping that Casey's going to give to her, because what she filed, I thought, in my opinion, was nonsensical in a lot of ways.
Yeah, I was just going to say, and rightly so, from what they filed.
Absolutely.
I know that we all had some raised eyebrows when we read through her reply because it didn't make sense. And you got to wonder if there wasn't some things said, discussions with the chief judge and maybe even other judicial whatever that has some impact on the circuit court. Some things that got said are like, why did you do this? Where are you going here?
Yeah.
Right?
Possibly.
I mean, there had to be. I mean, we're not lawyers and we're like raising an eyebrow at it. So.
Yeah, she strayed so far from the law in what she concluded.
Yeah.
Without an evidentiary hearing. I mean.
Yeah.
Then they let her bail out without, so that she can save face. Like, so, you know what I'm saying?
Give her an out. They gave her an out. The chief judge did. Yeah, I don't disagree, Sheree.
But that statement there has left the state wide open for an incredible amount of criticism, because in no case did they ever consider Bobby as a co-conspirator. That is indeed if Bobby was involved. I'm not saying he was, but it's interesting that the state never considered him as a potential co-conspirator. They basically considered Bobby, if he was involved, as someone merely helping out his uncle, right? And it's interesting that the line that they took, and what will be very interesting is if the roles were reversed. In other words, the spotlight was on Bobby Dassey all along, and if it was actually Stephen Avery that was caught bringing the RAV4 onto the property, would have the state actually said, "Oh, look, Stephen Avery was merely helping his nephew
out
to hide forensic evidence," right? Of course, the state would have never gone for that. But it's very interesting that the state has now considered that Bobby was merely helping his uncle.
Right. It's well,
at the same time of being the star witness for the state.
Yeah, that's what I was gonna say. Is she's got to draw that comparison here. Is it's not just that he could be a help. I mean, he turned out to be the star witness. No matter how many times the state wants to deny that, he absolutely was.
Oh, no doubt. No doubt.
He said he saw Teresa walking to Stephen's trailer.
Right.
Yep. Correct.
That's what was said at trial. Obviously, we know that there were things that were said, right after the incident. He told Loy's investigator he saw Stephen walking towards his own trailer.
Right.
The one word changes everything.
And he told other people that he saw her leave.
That's right.
Yep.
That's exactly right. Okay. As far as, unless there's something else, let's continue on.
Okay. Statement of the case and procedural history. This case began in early November of 2005 with the disappearance of Teresa Halbach, a 25-year-old professional photographer. Do you think we need to read the statement of the case since we're all so familiar? What do you guys want to do?
I think there's things within there it's worth reading.
Yeah.
Okay.
Okay.
Yeah. How she frames it.
Okay. Ms. Halbach was reported missing on November 3 of 2005. On November 5th of 2005, volunteer searchers found Ms. Halbach's Toyota RAV4 on the 40-acre site of Avery's Auto Salvage, a salvage yard business where Mr. Avery and other family members lived and worked. Ms. Halbach had photographed vehicles at this site previously per Mr. Avery's request. According to state witness Bobby Dassey, Ms. Halbach was last seen walking toward Mr. Avery's trailer on October 31, 2005. After finding Ms. Halbach's RAV4, law enforcement searched the Avery property and, over the course of the next 4 months, discovered and identified evidence including burned bone fragments in and around a burn pit, with DNA matching Ms. Halbach's, Mr. Avery's and Ms. Halbach's blood in the RAV4, the remnants of electronic devices and a camera, the same models as Ms. Halbach's, in a burn barrel. Ms. Halbach's RAV4 key in Mr. Avery's bedroom with Mr. Avery's DNA on it, Mr. Avery's DNA on the hood latch of the RAV4, deposited, the state later claimed, by Mr. Avery's sweaty hands, and a bullet in Mr. Avery's garage containing Ms. Halbach's DNA. During Mr. Avery's trial, Bobby was the state's primary witness against Mr. Avery. The state used Bobby's testimony to establish that Ms. Halbach never left the Avery property alive. In his opening statement, Prosecutor Kratz explicitly told the jury of the significance of Bobby's putative observations on the date of Ms. Halbach's disappearance. You are going to hear that Bobby was the last person, the last citizen that will have seen Teresa Halbach alive. Sorry, everybody. I couldn't help it. During the trial, During the trial, Bobby testified that he observed Ms. Halbach's SUV pulled up in his driveway at 2:30 p.m. on October 31, 2005. Bobby testified that he then observed Ms. Halbach exit her vehicle and start taking pictures of his mom's maroon van right in front of his trailer. Bobby testified that he then observed Ms. Halbach walking toward the door of Mr. Avery's trailer. The following exchange occurred between Kratz and Bobby. Question: after seeing this woman walking toward your Uncle Stephen's, did you ever see this woman again? Answer: no. On March 18, 2007, Mr. Avery was convicted of first-degree intentional homicide. Contrary to Wisconsin Statute 90401(1)A, and felon in possession of a firearm, contrary to Wisconsin Statute 941.29(2)A. The jury found Mr. Avery not guilty of mutilation of a corpse. On October 11, 2019, Mr. Avery appealed the circuit court's denial of his second post-conviction motion and all of its supplements. He filed motions to stay and remand concerning 2 additional claims. At this court's direction, Mr. Avery raised his claims and his motions to the circuit court as supplemental post-conviction motions. The circuit court denied his motions to supplement. During the pendency of Mr. Avery's appeal, a new witness, Mr. Sawinski, contacted Mr. Avery's current post-conviction counsel in December of 2020. Mr. Sawinski stated that he had witnessed Bobby and one other individual, a bearded man, pushing Ms. Halbach's RAV4 onto the Avery salvage yard in the early morning hours of November 5, 2005. Mr. Sawinski claimed that he had reported this information to the Manitowoc Sheriff's Office. On April 10 of 2021, Mr. Sawinski provided an affidavit to Mr. Avery's current post-conviction counsel stating that Mr. Sawinski was a motor route driver for Gannett Newspapers, Inc., and delivered papers to the Avery salvage yard in the early morning hours of November 5th of 2005. Prior to delivering the newspapers to the Avery salvage yard, he turned onto the Avery property and witnessed two individuals, a shirtless Bobby Dassey and an unidentified older male, suspiciously pushing a dark blue RAV4 down Avery Road toward the junkyard. The RAV4 did not have its lights on. Mr. Sawinski drove past the two men and delivered newspapers to the Avery mailbox. Then he turned around and drove back toward the exit. When he reached the RAV4 still over there, Bobby attempted to step in front of his car to block him from leaving the property. Mr. Sawinski came within 5 feet of Bobby, and his headlights were on Bobby during this entire time. Then Sawinski swerved into a shallow ditch to escape Bobby and exit the property. Mr. Sawinski states in his affidavit that he called out, quote, "Paper boy, gotta go," end quote, because he was afraid for his safety. He further stated that Bobby looked him in the eye and did not appear happy to see Mr. Sawinski there. After Mr. Sawinski learned that Teresa Hawbuck's car was later found in the day on November 5, 2005, he realized the significance of what he had observed and immediately contacted the Manitowoc Sheriff's Office. On April 12 of 2021, Mr. Avery filed a motion for remand and stay of appeal to this court containing Mr. Sawinski's original affidavit. On July 28 of 2021, this court issued a per curiam opinion upholding the circuit court's summary denial of Mr. Avery's claims raised in his 97406 post-conviction motion and two supplemental motions holding that, quote, Avery's 97406 motions are insufficient on their face to entitle him to a hearing, end quote. State v. Avery. However, this court did not remand Mr. Avery's case for a circuit court ruling on the claim in his most recent filing concerning the new witness, Mr. Sawinski, and reserved Mr. Avery's ability to raise this issue in a successive 97406 motion. Specifically, this court instructed the following. As discussed below, we are not addressing Avery's most recent filing to this court. See our discussion on motion number 6, which seeks to directly connect Dassey to Hawbuck's murder. If Avery wishes to raise that claim, he will need to bring a new 97406 motion. That motion would need to survive both Escalona Naranjo scrutiny and be found to have merit, in which case the evidence presented might supply the missing quote-unquote direct connection. In that event, the VLCD evidence might become relevant to showing Dassey's motive and might bear on whether Dassey is or should have been a viable Denny suspect. We express no opinion on the merit of any such 97406 motion, as all such issues would be for the circuit court to decide in the first instance. Regarding certain claims Mr. Avery raised in his motion to reconsider the circuit court's October 3, 2017 order denying his second post-conviction motion and its two supplements, this court found neither we nor the circuit court have squarely considered whether these claims are procedurally barred under Escalona Naranjo or whether Avery pled sufficient materials entitling him to a hearing. Such consideration would have to come on a separate filed 97406 motion, and we express no opinion as to whether such claims would be barred in the event such a motion is filed. Therefore, this court did not rule on certain issues contained in Mr. Avery's prior motion to reconsider, and its 2 supplements. On August 16, 2022, Mr. Avery filed his third motion for post-conviction relief pursuant to 97406. Mr. Avery filed an amended motion on December 6, 2022. Mr. Avery's 97406 motion set forth newly discovered evidence, excuse me, that third party, Bobby, was seen in possession of the victim, Ms. Halbach's vehicle after her disappearance. Mr. Sawinski contacted the Innocence Project about this matter in 2016. Although Mr. Sawinski originally believed it was Mr. Avery's trial defense attorneys that he contacted in 2016, after finding an email verification, he realized it was rather the Innocence Project he contacted, and thus he amended his original affidavit, which was submitted in Mr. Avery's motion, to stay his appeal to this court. And Mr. Sawinski's amended affidavit was filed to the circuit court reflecting this mistake. Affidavits from 2 other new witnesses in Mr. Avery's case, Mr. Kevin Romlow and Mr. Thomas Baresh, corroborate Mr. Sawinski's observations. Number 3 footnote. In Mr. Romlow's affidavits provided to the circuit court, Mr. Romlow described observing Ms. Halbach's RAV4 parked at the turnaround at State Highway 147 and the East Twin River Bridge on November 3 and 4, 2005. Mr. Romlow stated that he reported his observations to the Manitowoc Sheriff's deputy he encountered on November 4, 2005 at the Senex station on State Highway 147 in Mishicot. In Mr. Thomas Baresh's affidavit, he states that sometime before 2 a.m. on November 5th, he was driving a tow truck in the area of Highway 147 and County Road Q in Manitowoc County and saw a RAV4 driving south on County Road Q, turning left off of County Road Q as it passed him. Although he did not recognize the passenger in the vehicle, he is 100% sure it was not Mr. Avery. Oh, okay, now I see. In Mr. Avery's 97406 motion, Mr. Avery also raised Brady claims relating to the information from the new witnesses. Mr. Avery attached affidavits and documents showing that after Mr. Sawinski contacted Mr. Avery's current post-conviction counsel and provided the newly discovered evidence, Mr. Avery's current post-conviction counsel, through its investigator, submitted its second public records request pursuant to the Freedom of Information Act, FOIA, for audio recordings of incoming and outgoing phone calls and/or radio dispatches between November 3, 2005 and November 9, 2005 relating to this case. The FOIA-produced audio recordings did not contain the Sawinski call, nor did they contain any dates or times of the calls produced. In May of 2022, Mr. Avery's current post-conviction counsel received the previously suppressed Sawinski call to the Manitowoc Sheriff's Office, which contained a partial recording of the suppressed call to the Manitowoc Sheriff's Office on November 6. For the first time, current post-conviction counsel received the exact dates and times of the Manitowoc County Sheriff's Office incoming calls. As part of its investigation, Mr. Avery's investigator then interviewed Mr. Sawinski's ex-girlfriend, whom he was dating at the time of the November 5, 2005 incident. Mr. Sawinski's ex-girlfriend, Devin Novak, corroborated Mr. Sawinski's account of what he had witnessed and what he had relayed to law enforcement. Further, Ms. Novak recognized and identified Mr. Sawinski's voice on the recording played to her by the investigator of a phone call made to the Manitowoc Sheriff's Office on November 6, 2005 at 10:28 p.m. Mr. Avery's investigator interviewed Mr. Sawinski again and played the same audio recording of the phone call that was made to the Manitowoc Sheriff's Office on November 6, 2005 at 10:28 p.m. Mr. Sawinski identified his voice in the audio recording of the phone call from November 6, 2005. The recording of Mr. Sawinski's call was never disclosed by the state to Mr. Avery's trial defense counsel prior to or during the trial. Pre-trial, trial defense counsel made two specific requests for all exculpatory evidence and/or information within the possession, knowledge, or control of the state, which would tend to negate the guilt of the defendant, or which would tend to affect the weight or credibility of the evidence used against the defendant, including any inconsistent statements. Pertaining to the Brady claim, stemming from the evidence from Mr. Romlow, Mr. Romlow described in his affidavit that he reported his observation to a Manitowoc Sheriff's deputy he encountered on November 4, 2005 at the Senex station on State Highway 147 in Mishkat. No law enforcement report was ever generated by this Manitowoc Sheriff's deputy memorializing the conversation between Mr. Romlow and this deputy about Mr. Romlow's observation of Ms. Halbach's vehicle. The circuit court denied Mr. Avery's motion for post-conviction relief on August 22nd of 2023. Mr. Avery filed a timely notice of appeal on August 24, 2023. This appeal follows. Argument 1. Whether this court must conduct a de novo review of the sufficiency of Mr. Avery's motion for post-conviction relief on its face because of the circuit court's failure to conduct any such analysis as a matter of law. In the circuit court's opinion dismissing Mr. Avery's third motion for post-conviction relief, the circuit court failed to consider Mr. Avery's request for an evidentiary hearing. The circuit court, quote, must determine first whether the motion on its face alleges sufficient material facts that, if true, would entitle the defendant to relief, end quote, from State v. Ruffin, citing State v. Allen. As with any other civil pleading, in assessing the legal sufficiency of the motion, the court must assume the facts alleged therein to be true. Gritzner v. Michael R. Only after an evidentiary hearing is the court charged with determining the issues and making findings of fact and conclusions of law. Wisconsin Statute 97406, 3D. The circuit court.
Susan, can I pause you
Yes.
for just a second? Our
You
power
bet.
flickered like 3 times, and I lost internet.
my.
So what page are we on?
We are on 16 of the PDF.
Okay.
So are we offline here?
No. It was on my end. No, it continued to go on YouTube.
Okay.
Are you at the top of the page of 16?
In the second paragraph, I believe.
Okay.
Ready to go?
Yep.
The circuit court improperly attempted to weigh Mr. Avery's facts with speculative theories unsupported by the record, rather than accepting his facts as true and determining whether they were sufficiently pled to warrant an evidentiary hearing. Despite the fact that the circuit court opened its opinion claiming, quote, The defendant is back before the circuit court, end quote. The circuit court failed to conduct any analysis of whether Mr. Avery pled sufficient facts to warrant an evidentiary hearing on his newly discovered evidence. Rather, in its opinion, the circuit court weighed Mr. Avery's evidence as if it had already been presented during an evidentiary hearing. An evidentiary hearing is nothing more than an intermediate step toward the objective of being granted a new trial. It is not an end in itself. The evidentiary hearing is a forum to prove allegations in a motion for post-conviction relief. See State v. Bayet. Mr. Avery's motion for post-conviction relief states what he is set to prove if he were granted an evidentiary hearing. She's teaching them the law here. An evidentiary hearing would provide Mr. Avery with the opportunity to prove his pleaded claims that he is entitled to a new trial. Bayet. Avery's motion contained all the proof necessary to show that he was entitled to a new trial. He would not need, if Mr. Avery's motion contained all the proof necessary to show that he was entitled to a new trial, he would not need an evidentiary hearing. In Mr. Avery's prior appeal to this court, after the circuit court denied his second motion for post-conviction relief, this court properly was guided by the law for determining whether an evidentiary hearing is warranted. This court correctly stated the law, quote, where, as here, a defendant appeals the circuit court's denial of a 97406 motion without an evidentiary hearing, then the question before us is narrow, whether remand for a hearing is warranted because the circuit court erred in denying the motion on its face, end quote, citing Bayet or Balliet, whatever it is. This court correctly noted the two potential standards for determining whether the circuit court erred in failing to grant an evidentiary hearing. The first being, quote, the circuit court must hold a hearing where the motion is sufficient on its face, unless the record as a whole otherwise conclusively demonstrates that the defendant is not entitled to relief, end quote. Balliet, State v. Howell. This is a question of law reviewed de novo, State v. Romero-Georgiana. Additionally, this court noted, quote, if the motion does not raise sufficient facts or presents only conclusory allegations, or if the record conclusively demonstrates that the defendant is not entitled to relief, end quote, then, quote, the circuit court has the discretion to grant or deny a hearing, end quote, citing Balliet. In such a case, this court reviews for an erroneous exercise of discretion, Romero-Georgiana. Here, the circuit court never conducted any analysis on whether Mr. Avery pled sufficient facts to warrant an evidentiary hearing, nor made the requisite finding pursuant to State v. Jackson that, quote, the record conclusively demonstrates that the defendant is not entitled to relief, end quote. This court should reverse the circuit court's ruling denying Mr. Avery's motion because it failed to make the requisite finding established by case law. Number 2, whether the circuit court improperly imposed a burden on Mr. Avery to conclusively prove the Denny motive element in order to satisfy the materiality prongs of State v. Edmonds and Brady v. Maryland. This circuit court misapplied State v. Edmonds by requiring Mr. Avery to conclusively establish Bobby's motive to murder Ms. Halbach in his motion on its face in order to satisfy the materiality requirement of Edmonds. A standard review. An appellate court reviews a circuit court's determination as to whether a defendant has established his or her right to a new trial based on newly discovered evidence for an erroneous exercise of discretion. A court properly exercises its discretion if it relies on the relevant facts in the record and applies the proper legal standard to reach a reasonable decision. Thus, this court will find an erroneous exercise of discretion if the circuit court's factual findings are unsupported by the evidence or, and this is underlined, if the court applied an erroneous view of the law. State v. Edmonds. B. Burden of proof. On a motion for post-conviction relief pursuant to Wisconsin Statute 97406, a defendant has the burden of proof. 97406. The defendant must show his entitlement to relief by clear and convincing evidence. State v. Roll. To obtain an evidentiary hearing on a motion for a new trial on the basis of newly discovered evidence, the defendant first, quote, must show specific facts that are sufficient by clear and convincing proof, end quote, to demonstrate that, quote, 1, the evidence was discovered after conviction. Number 2, the defendant was not negligent in seeking the evidence. And 3, the evidence is material to an issue in the case. And 4, the evidence is not merely cumulative, end quote. Edmonds. C. Argument. The circuit court found that Mr. Avery satisfied all the elements required to admit his newly discovered evidence, quote the Sawinski evidence. But for the materiality requirement of Edmonds, the circuit court imposed a new Denny requirement that Mr. Avery must establish that Bobby had a motive, established by conclusive evidence, to commit the murder of Miss Halbach to meet the Edmonds materiality requirement. Specifically, the circuit court stated, a review of the record and the defendant's argument reveal that he has failed to satisfy the third standard of the Edmonds test, as well as the motive element of the Denny test. With respect to the Edmonds test, the defendant argued that the evidence offered was material to an issue in the case because it established that there was a viable third-party suspect that could have committed the murder of Ms. Halbach, and such evidence was never presented to the jury for consideration, undermining confidence in the verdict reached. In order to meet that burden, the defendant had to prove that the evidence also met the standards set forth in Denny to be admissible as proof of a third-party suspect. The defendant failed to establish that Bobby had the requisite motive to commit the murder of Ms. Halbach. According to the circuit court, Mr. Avery would have to satisfy two tests for the circuit court to admit, quote, the affidavit of Sawinski, end quote, into evidence. The circuit court improperly found that the materiality of Mr. Avery's newly discovered evidence is exclusively contingent upon its satisfaction of the Denny test for admissibility of potential third-party suspect evidence. In determining that Mr. Avery's new evidence could only be material to the issue of a potential third-party suspect, the circuit court completely ignored the inherent materiality of the Sawinski evidence to other material issues in Mr. Avery's case. In Mr. Avery's third motion for post-conviction relief, he argued, The Sawinski evidence is material to several issues in Mr. Avery's case. It is material for establishing Mr. Avery's defense, that is, that a third party committed the crime against Ms. Halbach. Additionally, the Sawinski evidence is material to the evidence in the RAB-4 being planted by Bobby, including Mr. Avery's blood and DNA. The RAB-4 also contained the Halbach vehicle key and Ms. Halbach's electronic devices, which were discovered in Mr. Avery's bedroom and burn barrel, respectively. Further, the Sawinski evidence is material to impeach Bobby's trial testimony that Ms. Halbach never left the Avery property and that she was last seen walking toward Mr. Avery's trailer. The new evidence showing that Bobby had possession of Ms. Halbach's vehicle is highly material for evaluating the reliability of the forensic evidence used against Mr. Avery, which all happened to be derived from Ms. Halbach's vehicle. Crucially, it is also material to the reliability of the state's key witness against Mr. Avery, Bobby himself. This court pointed out in paragraph 4 of its opinion from July 28 of 2021, quote, "The state's theory was that Avery shot Halbach in the head in his garage and threw her in the cargo area of the RAV4. He then burned the electronics and camera, cremated Halbach in a burn pit, transferred the remains to a burn barrel, and hid the RAV4 until he could crush it in the Avery car crusher." End quote. Mr. Avery's new evidence shows that the vehicle did leave the Avery property and was in possession of a third party. Additionally, this new evidence debunks the state's theory against Mr. Avery that he kept the RAV4 on the Avery property by the crusher so he could crush it immediately. The evidence of Bobby's possession of Ms. Halbach's vehicle is material because it shows that Bobby had possession of the forensic evidence used to convict Mr. Avery. The vehicle was the crime scene by virtue of having all of the relevant forensic evidence in it, including Ms. Halbach's blood. The Sawinski evidence establishes that Bobby, the state's star witness, had control of the crime scene for a period of time. Despite police searches preceding the discovery of Ms. Halbach's vehicle, Ms. Halbach's electronic devices and key were not found until after Ms. Halbach's vehicle was found. The only logical conclusion to explain this is that all the items remained in Ms. Halbach's vehicle and were then moved by whoever had possession of her vehicle. If a third-party suspect had possession of Ms. Halbach's vehicle, numerous areas of reasonable doubt arise, such as that the forensic evidence in the vehicle is tainted by the third party having control of it before it was discovered by law enforcement on the Avery property. This would have created reasonable doubt in the jurors' minds, particularly since the state's star witness was the one in possession of the vehicle. Thus, Mr. Avery's new evidence also presents an alternative theory for the source of the forensic evidence used against Mr. Avery. See Edmonds. State v. Edmonds is the leading case on newly discovered evidence. In Edmonds, the defendant was convicted of the death of an infant she was caring for at the time of the infant's death. The defendant filed a motion for a new trial over a decade after her trial and offered medical testimony that showed that there had been a shift in mainstream medical opinion as to the cause of the types of injuries the infant suffered. The court found that the evidence was material to an issue in the case because the main issue at trial was the cause of the infant's injuries, and the new medical testimony presented an alternate theory for the source of those injuries. Edmonds. Here, applying Edmonds, Mr. Avery's new evidence is material to a key issue in Mr. Avery's case, because Mr. Avery's new evidence that Bobby had possession of Ms. Halbach's vehicle after her murder presents an alternative theory for the source of the evidence used to convict Mr. Avery. The Sawinski evidence is additionally material because it completely calls into question the reliability of the state's key witness, Bobby's testimony, which allowed the state to argue that Mr. Avery had exclusive control of Ms. Halbach and her vehicle, which contained all of the forensic evidence, and that this evidence was not tainted by any third party. During its closing argument, the state emphasized the importance of Bobby's testimony and vouched for his credibility. Quote, again, an eyewitness without any bias. It is an individual that deserves to be given a lot of credit, end quote. With the new Sawinski evidence, as well as Mr. Romlow's affidavit, the state could not possibly have presented Bobby to establish that Ms. Halbach never left the property in her vehicle and that she was last seen walking toward Mr. Avery's trailer. The state's critical witness link to obtaining Mr. Avery's conviction. Clearly, by Bobby possessing the Halbach vehicle, there is a reasonable likelihood it would have affected the judgment of the jury, in that Bobby would have emerged as a much more likely suspect in the murder of Ms. Halbach than his recently released, wrongfully convicted uncle. Contrary to the state's representations to the jury, Bobby was biased and deserved no credit for his fabricated testimony. The United States Supreme Court in Weary v. Kane held, Brady applies to evidence undermining witness credibility. Evidence qualifies as material where there is, quote, any reasonable likelihood, end quote, it could have, quote, affected the judgment of the jury, end quote. To prevail on his Brady claim, Weary need not show that he, quote unquote, more likely than not, would have been acquitted had the new evidence been admitted. Additionally, in regard to a motion for a new trial, a reasonable doubt as to a defendant's guilt has been found to exist when the reliability of a witness critical to the state's case is completely called into question by newly discovered evidence. State v. Wilson. Quote, a new trial is required if the false testimony could, in any reasonable likelihood, have affected the judgment of the jury, end quote. Giglio v. United States. And let's see also State v. Plude. Quote, Wisconsin law has long held that impeaching evidence may be enough to warrant a new trial, end quote. Ooh, that's a good one. In State v. Plude, the defendant presented newly discovered evidence that an expert witness lied about his credentials. The Supreme Court of Wisconsin found that because, quote, the expert witness's testimony was a critical link in the state's case, end quote. Quote, the expert witness's quasi-medical expert testimony creates a reasonable probability that the jury hearing of his false testimony about his credentials would have had a reasonable doubt as to his guilt. Notably, in Justice Annette Ziegler's concurrence with the majority opinion, she wrote that the, quote, new allegations, end quote, that the expert witness misrepresented his credentials about his affiliations and work experience created a serious question as to whether the interests of justice were served. Here, Mr. Avery presents a stronger case about the materiality of his newly discovered evidence because he does not just allege that it shows that Bobby misrepresented facts in his testimony. He alleges that the Sawinski evidence shows that Bobby committed perjury in his testimony, that he left the property and did not see Ms. Halbach again. Furthermore, the newly discovered evidence taints all of the forensic evidence used against Mr. Avery, which resulted in his conviction. In this court's previous opinion on July 28 of 2021, this court did not believe that the impeachment of Bobby was material because it found that there was significant forensic evidence linking Mr. Avery to the crime. However, the Sawinski affidavit establishes Bobby's possession of the Halbach vehicle undermines confidence in the reliability of the forensic evidence used against Mr. Avery. This strengthens the materiality of the impeachment evidence against Bobby. In his motion for post-conviction relief, Mr. Avery satisfied Edmonds. Once the 4 criteria of newly discovered evidence have been established, the court looks to whether a reasonable probability exists that a different result would be reached in a trial. The reasonable probability factor need not be established by clear and convincing evidence, as it contains its own burden of proof. Edmonds. With regard to a motion for a new trial, the correct legal standard when applying the, quote, reasonable probability of a different outcome, end quote, criteria is whether there is a reasonable probability that a jury, looking at both the old and the new evidence, would have a reasonable doubt as to the defendant's guilt. A court reviewing newly discovered evidence should consider whether a jury would find that the newly discovered evidence had a sufficient impact on other evidence presented at trial that a jury would have a reasonable doubt as to the defendant's guilt. That's from Plude, I believe, or Plude, whatever that is. Here, the circuit court again failed to analyze Mr. Avery's evidence under the proper test because of its improper requirement that Mr. Avery satisfy the Denny motive prong in order to show the materiality of his evidence, even for purposes of Brady. The circuit court did not dispute that the prosecution had suppressed the audio recording of Mr. Sawinski's call. Rather, it disputed the materiality and favorability of the evidence to find that Mr. Avery failed to establish a Brady violation with respect to the Sawinski evidence. Rather than making the required finding that there was no reasonable probability that a jury hearing Mr. Avery's new evidence could have a reasonable doubt as to Mr. Avery's guilt, the circuit court engaged in weighing the evidence of the violent porn found on the Dassey computer and concluded that the evidence does not conclusively show that it was solely acquired by Bobby on the computer.
It's a good place to break for a minute if you want.
Yeah.
Hello? You've read quite a bit there, so
yeah.
This is a good this is a good natural break. So, comments, because she hammered pretty good there.
Wow.
I'm certainly not a lawyer, but her reasonings.
It's all just common sense to me.
Yeah, I agree. Doc, anyone? Duke, comments? Cherie, Katie.
I mean, for me, I agree with what Susan says. It is common sense. And it's quite clear here that the judge does not want Kathleen Zellner to present her new material in front of a judge. because if this evidence is real, if Bobby Dassey was indeed in possession of Teresa Halbach's vehicle, this is going to be very, very damaging. And quite clearly, the judge is doing everything in her power to prevent an evidentiary hearing. And what is very interesting in the podcast that we're going to be doing tomorrow, as I've already said, we're going to be expanding this very topic in greater detail and deep diving into it. It's to me, this is really a crossroad moment. It really is that serious. It really is that important, especially for the exoneration of Stephen Avery and potentially Brendan Dassey. This is huge.
Can I just, and I may be wrong, I don't know if anybody had addressed Lisa Zakowski's comment. She said apparently it's been rejected by the court. It was filed incorrectly this morning. It had the appendix along with the brief, and they were supposed to be filed separately. But since then, it has been correctly filed, and the brief is actually on the Court of Appeals site. So that's been taken care of.
Yeah, and this, you can see the copy that, well, I'm not going to scroll back up yet, but the copy at the top is stamped by the court. So.
And it was filed today.
Yes, it was filed today.
Yeah.
So whatever errors errors happen have been corrected.
And it looks like my first glance, it showed that the state's response is tentatively due by February 12th at this point.
Well, that's nice.
Yeah, I think they have 30 days.
Yeah. Can they ask for more time? They probably will.
I think sure they will.
I think they can ask for an extension, but I don't think it's a real long extension that they grant. If I'm remembering the previous Court of Appeals, because theirs is different than the allowed extension time. I think is shorter.
I think you're right, Jack.
TJ Anderson says refiled today. Well, it was filed today, TJ, and it was something, as Susan said, that it was filed. The appendix was incorrectly attached or something, but that got corrected, and they refiled it.
It was supposed to be filed separately. Yeah.
Yeah.
So they redid it. Yeah.
Yeah. It's all good now. So it is filed, stamped, and so forth.
I was worried we were going to have to wait till Monday, but they got it in.
Yeah.
4:30 or something.
Okay. Well, I don't think, I want to make the statement here, no matter where you stand in the trial, not that trial, the facts or these things that Casey's saying, people will believe whatever they want. We're not saying that we necessarily believe or disbelieve or whatever Casey's putting forth. I mean, it's reasonable to me. I'm not saying that she's necessarily wrong, because the truth is Bobby was a star witness for the state. And maybe that sounds awful to some people, but that's fact. We've had this discussion at length, ad nauseum, actually. But,
he was present. He was there when Teresa was there.
That's right.
So he was very important.
Well, then November 23rd, 2005, he tells, as I said earlier, he tells Loy, Avery's first attorney and their investigator, that he saw Stephen walking back towards his trailer, not Teresa. It's a complete change of statement, and it changes the entire complexity of the case. Yep.
Yeah, and whether people want to believe Sawinski or not, he's written an affidavit, and it's on the court to take that as truth. Whether anyone likes it or not, that's what they have to do.
Okay. All right. Is everybody ready to continue on? I get this back on screen here.
Who are you going to have read, Chuck?
You want to take a break?
Yeah, I'll take a break.
Okay. Doc, you feel like reading for a bit?
Yes, I can. I could read a little bit.
Absolutely. Read however much you want. Break wherever you want. Again, questions in the live chat. Put a Q in front of it, and we'll try to address it. Anytime you're ready, Doc.
Okay. 3. Whether the circuit court erred when it did not correctly apply State v. Denny to Mr. Avery's potential third-party suspect evidence. In his motion for post-conviction relief, Mr. Avery presented evidence implicating his constitutional right to present a defense that a potential third party committed the murder of Miss Horbach. However, the circuit court did not correctly apply Denny to the admissibility of Mr. Avery's evidence of a potential third party suspect. It erroneously imposed a substantial certainty requirement upon Mr. Avery's evidence and completely misapplied Denny in its evaluation of whether Mr. Avery's evidence satisfied the Denny elements of motive, opportunity, and direct connection. A. Standard of review. This court generally reviews a trial court's decision to admit or exclude evidence under an erroneous exercise of discretion standard, State v. Wilson. However, when a defendant's constitutional right to present a defense is implicated by the exclusion of evidence, the decision not to admit the evidence presents a question of constitutional fact that the court reviews de novo, State v. Ramsey, State v. Knapp. B. Burden of proof. On a motion for post-conviction relief pursuant to Section 974.06, the defendant has the burden of proof, Sec. 974.06(6) Stats, and must show his entitlement to relief by clear and convincing evidence, Roll versus State. C. Argument. Denny governs the admissibility of potential third-party perpetrator evidence in Wisconsin. Denny requires a showing that, quote, there must be a legitimate tendency that the third person could have committed the crime, end quote. State v. Denny. A legitimate tendency is demonstrated where the defendant can establish 1. Motive, 2. Opportunity to commit the charged crime, and 3. Provide some evidence to directly connect a third person to the crime charge which is not remote in time, place, or circumstances. In its opinion, dismissing Mr. Avery's motion for post-conviction relief, the Circuit Court acknowledged that the standard for evaluating the admissibility of evidence of a potential third-party suspect is set forth in Denny. However, rather than applying the Denny standard, the Circuit Court applied a stricter standard which Wisconsin does not follow. In Denny, the Wisconsin Court of Appeals rejected the standard set forth by the California Supreme Court in People versus Green. Specifically, the Denny Court disagreed with the Green Court's conclusion that such evidence must be substantial, stating, quote, we perceive this to be too strict a standard for the admissibility of such evidence and conflicts with our Supreme Court's pronouncements on the fundamental standards of relevancy. Denny at 623. The Denny Court clarified, relevant evidence means evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. This rule does not say that the evidence must tend to prove a fact in a substantial way. Rather than requiring any level of substantial certainty, Denny adopted the standard set forth in the earlier Supreme Court case, Alexander versus United States. There, the Supreme Court fashioned the legitimate tendency test, where the standard for evaluating the evidence is that it must show a legitimate tendency that the third party could have committed the crime. Alexander at 356-57. In adopting the Supreme Court's test for materiality, the Denny Court elaborated, quote, "We believe that to show legitimate tendency," and the following is underlined, "a defendant should not be required to establish the guilt of third persons with that degree of certainty requisite to sustain a conviction in order for this type of evidence to be admitted." Denny at 623, emphasis added. If the Circuit Court had correctly applied Denny, it would have found that Mr. Avery had provided sufficient evidence to satisfy the standard set forth by Denny. The Denny Court differentiated between evidence which supports a legitimate tendency and evidence that simply affords a possible ground of suspicion against another person, which is merely evidence tending to show that hundreds of other persons had some motive or animus against the deceased. Denny at 623. Unlike the inadmissible type of evidence that the Denny Court described, Mr. Avery's evidence is very specific to Bobby and establish a direct connection between Bobby and the crime. See Denny at 624. Hundreds of other persons did not have possession of Miss Horbach's vehicle and also have photographs of young mutilated females on the computer of which they are the primary user. The legitimate tendency test asks whether the preferred evidence is so remote in time, place, or circumstances that a direct connection cannot be made between the third person and the crime. Again, Denny does not require a conclusive showing of Bobby's guilt. Rather, it establishes a standard for establishing a potential third-party suspect, which is a material issue in any murder case. Denny states that, quote, "As long as motive and opportunity have been shown, and as long as there is also some evidence to directly connect a third person to the crime charge, which is not remote in time, place, or circumstances, the evidence should be admissible," end quote. Emphasis added. Where Mr. Avery has preferred evidence that Bobby Dassey had possession of Miss Horbach's vehicle after she went missing, had most likely been conducting computer searches relevant to Miss Horbach's murder and was on the Avery property before Miss Horbach's disappearance and after her disappearance, no reasonable trier of fact correctly applying the law would find that Mr. Avery has not established some evidence directly connecting Bobby to the crime charged. 1. The Circuit Court erroneously evaluated the motive, opportunity, and direct connection elements of Denny. As this court pointed out in its opinion previously, the evidence in support of Denny must be viewed in the aggregate. Rather than viewing Mr. Avery's evidence in the aggregate, the Circuit Court required Mr. Avery to present conclusive proof to satisfy each prong individually. However, quote, each piece of a defendant's preferred evidence need not individually satisfy all three prongs of the Denny test, State versus Wilson. Further, the Wisconsin Supreme Court has determined the, quote, strength and proof, end quote, of one of the prongs may, quote, affect the evaluation of the other prongs, end quote. See State versus Wilson. The Circuit Court completely ignored these well-established principles of law in evaluating the motive, opportunity, and direct connection elements of Denny. 2. Motive elements of Denny. In Mr. Avery's motion for post-conviction relief, he alleged that the motive attributed to Bobby for Miss Horbach's murder could have been sexual and provided evidence supporting this, namely the suppressed evidence from a computer that was in Bobby's bedroom. According to his brother Blaine's affidavit, Bobby was the primary user of this computer. Bobby lied to police about the location of the computer, claiming it was in the living room. But crime scene footage showed it was in his bedroom. The computer was examined and revealed searches highly relevant to the murder of Miss Horbach, which occurred during times in which the state has been unable to rule Bobby out as having conducted them. The state argued that other members of the Dassey household could have conducted the searches, a supposition that may or may not be true, but no other member of the Dassey household was spotted by a witness with Miss Horbach's vehicle shortly after her disappearance. Bobby's possession of the vehicle, with all of the forensic evidence used to convict his uncle, combined with the violent pornographic searches on the computer in his bedroom, of which he is the primary user, elevate him to the level of a Denny third-party suspect. The Circuit Court spent 12 pages of its 31-page opinion weighing Mr. Avery's motive evidence, which is improper and contrary to the law on motive. The issue is whether the pornographic searches on the Dassey computer are relevant to motive regardless of the weight. In its opinion, the Circuit Court noted, quote, the state further disputes the defendant's conclusion that law enforcement considered pornography or sexual assault as a motive for the murder in this matter, end quote. In dismissing Mr. Avery's motive evidence, the Circuit Court adopted this erroneous position from the state's response brief. However, this point is completely refuted by the record. On March 10th, 2006, the state filed an amended information against Mr. Avery, adding the charge of sexual assault among others. This amended charge was the result of Brendan Dassey's confession on March 1st, 2006. Mr. Avery's trailer and his computer were searched extensively for pornography, and none was found. Detective Bailey was asked to generate a report of Mr. Avery's computer. Based on Detective Bailey's report, no apparent searches of pornographic and or sexual images were made, and no websites with apparent sexual and or pornographic images were accessed. In further search for evidence to support a sexual assault motive, the Dassey computer was seized by law enforcement on April 21st, 2006. In the affidavit for search warrant for Dassey computer, Special Agent Tom Fassbender testified, "Your affiant believes that said computer may contain images, records, and messages which may be relevant to the investigation into the homicide of Teresa Horbach. Your affiant further believes that information contained on said computer may include evidence of the crimes of homicide, mutilating a corpse, and sexual assault," emphasis added. Again, the Circuit Court misstated the evidence by relying upon the state's misrepresentations that the investigation was not focused on a sexual motive. Law enforcement made great efforts to extract all the pornography from the Dassey computer, and even went so far as to have Detective Bailey conduct specific word searches related to the murder in an effort to connect the pornography to the murder. The specific search terms results were body, 2083, stab, 32, throat, 2, bullet, 10, DNA, 3, fire, 51, gas, 50, RAV, 74, gun, 75, handcuff, 2, bondage, 3, blood, 1, and tire, 2. The Bailey CD contains the state's recovered pornography images relevant to the Horbach murder. On the CD, Detective Bailey refined 14,099 images on the 7 DVDs and recovered 1,625 violent pornography images that had been deleted. The CD contains thousands of images of violent pornography, criteria, word searches, registry, internet history, Windows history, and all MSN messages, all of which reveals a propensity for sexual violence. Without an evidentiary hearing, it cannot be conclusively established that Bobby was conducting these searches. Yet, Mr. Avery provided sufficient evidence concerning the schedule of the occupants of the Dassey residence to eliminate certain individuals that could have had access to the computer from many of the violent pornographic searches. Mr. Avery has been unable to get an affidavit from Bobby admitting he conducted the searches, nor someone from the Dassey household stating they saw Bobby performing the searches, which the circuit court seems to be requiring. Moreover, Bobby did not volunteer for a forensic or psychological examination by Mr. Avery's experts, as the circuit court suggests is required. Based upon the findings of Mr. Gary Hunt, Mr. Avery's forensic computer expert, 667 sexual content searches were performed in total. Of those searches, 562 were performed on 10 weekdays between 6 a.m. to 3:30 p.m., 8/16/2005. 4 searches, 9/13/2005. 12 searches, 2/23/2005. 48 searches, 3/29/2006. 37 searches, 3/30/2006. 23 searches, 4/3/2006. 93 searches, 4/5/2006. 96 searches, 4/6/2006. 14 searches, 4/13/2006. 39 searches, 4/19/2006. 196 searches. Therefore, 64 sexual content searches were performed prior to Miss Horbach's murder between 6 a.m. to 3:45 p.m., when Bobby was allegedly home alone, if the family's reported schedules are taken to be true. Another 500 searches were performed in this same time frame after the murder, when Bobby was supposedly home alone. In its response to Mr. Avery's motion for post-conviction relief, the state conceded that Bobby is at least connected to 3 of the most violent searches prior to Miss Horbach's murder, and inadvertently conceded that Bobby is connected to 25 of the searches after Miss Horbach's murder. Bobby cannot be eliminated by the state from any of the pornographic searches, especially the ones conducted prior to and very close in time to Miss Horbach's murder. And he is the only family member who was seen with Miss Horbach's vehicle after her disappearance. The circuit court erroneously concluded that the searches done after Miss Horbach's murder have no weight. However, conduct of a suspected person after the crime is a legitimate subject for consideration as bearing upon the probability of his guilt. Motive can manifest itself after the crime when the perpetrator is reliving and fantasizing about the crime. The continued searches for violent pornography demonstrate that the motive for this murder was a sexual assault. It is highly significant that the searches for deceased, mutilated young women began after, not before, the murder and mutilation of Miss Halbach. The searches after the murder coincide with the fact that a young woman was murdered and mutilated. The searches before the murder coincide with thousands of images of young women engaging in sexual activity, many unwillingly, and corroborate a sexual assault motive. See State versus Silva. The Circuit Court also completely ignored Mr. Avery's evidence of the Dassey computer deletions, which infer a consciousness of guilt. Significantly, many of the Dassey computer searches had been deleted, and only some of those were recovered, which leads to questions such as, who in the Dassey household deleted the searches? Why were these searches deleted before Mr. Avery's trial? To make the proper credibility findings on this issue, an evidentiary hearing must be held. It is highly significant in any investigation if there is an attempt to delete or destroy records. See State versus Renier. In brackets, in this sexual assault case, the appellate court found, quote, the defendant's consciousness of guilt was also evidence, as he told the victim to delete the text messages the two had exchanged, end quote. See also State versus Mercer, in brackets, where the appellate court found the fact that, quote, the jury heard evidence from which it could infer that Mercer deleted the files where the forensic examiners would have found the child pornography stored in his hard drive, end quote, was significant evidence of the defendant's guilt. Mr. Hunt identified 8 times when there were deletions on the Dassey computer. The deletions are very important because they correlate with Miss Halbach's visits to the property. Miss Halbach visited the property on August 22nd, 2005, and there are deletions on the Dassey computer from August 23 through August 26, 2005. She visited the property on August 29, 2005, and there are deletions from August 28, 2005 through September 11, 2005. She visited the property on September 19, 2005, and there are deletions from September the 14th, 2005 through September 15, 2005. There are also deletions from September 24, 2005 through October 2005. Most significantly, around the time of her murder on October 31st, 2005, there were deletions from October 26, 2005 to November the 2nd, 2005. Beginning November the 3rd, 2005, there were further deletions made on the Dassey computer. These deletions at the above described relevant times cannot simply be dismissed as mere coincidences. The Circuit Court misconstrued the holding in Dressler versus McCautry by adopting the state's argument that the pornographic images must be a mirror image of the crime or they have no relevance. The court in Dressler made no such ruling and held that, quote, "The pictures depicting violence were offered to prove Dressler's fascination with death and mutilation and this trait, in brackets, of Dressler is undeniably probative of a motive, intent, or plan to commit a vicious murder," end quote. Likewise, here, most of the Dassey computer pornography consists of images depicting violence, in brackets, even race car accidents, end bracket. They show a fascination with death and mutilation. And this trait of the Dassey pornographic consumer is, bracket, quote, "undeniably probative of a motive, intent, or plan to commit a vicious murder," end quote. Mr. Avery provided the circuit court with specific searches on the Dassey computer of terms such as, quote, "someone who was shot," end quote, and searches for a, quote, gun to head, end quote. There were 8 searches prior to Miss Horbach's murder on 9/17/05 for, quote, "skeleton," end quote, "a live skeleton," end quote. After the murder, there were 6 searches for, quote, "girl guts," end quote, and 15 searches for, quote, "girl hurt," end quote, and 2 searches for, quote, "seeing bones, hot girls," end quote. These searches mirror the fate of someone hurt, shot in the head, mutilated, and burned into skeletal remains, which is the total amount of information known about Miss Horbach's fate. More importantly, these images reveal the trait of the Dassey pornographic consumer that is probative of motive, intent, or plan to commit vicious murder. Contrary to the circuit court's view, the proper standard does not require Mr. Avery to establish his evidence of Bobby's motive with absolute certainty. In fact, this level of certainty has never been required by any court in Wisconsin to satisfy the motive element of Denny or any element of the Denny analysis, for that matter. See State versus Knapp, in brackets, where the Wisconsin Supreme Court has even deemed hearsay evidence as permissible evidence for satisfying all 3 prongs of the Denny test, including motive, in bracket. Under the motive prong, the court simply must question whether, quote, "the alleged third-party perpetrator had a plausible reason to commit this crime." Wilson. See also State versus Volbrecht. In bracket, evidence of a general motive is sufficient to prove this prong of the Denny test, in bracket. Further, because motive is never an element of any crime and the state never needs to prove motive, relevant evidence of motive is generally admissible, regardless of weight. Wilson. See also State versus Burby.
Doc,
Yes.
I just want to interrupt you for 1 minute. Jack, someone has asked if you could slow the scrolling a bit.
I can.
Would you like me to read slower?
No, I think your reading's
it's
fine.
just scrolling.
I just try to keep up because there's always the delay, but yeah, I can definitely slow it down. No problem.
Would
Thank
you like me to
That was
continue?
Jennifer.
Yep, please
Yes.
continue.
Mr. Avery's third-party motive evidence is relevant regardless of the weight assigned to it by the Circuit Court. This is precisely in line with the court's prior guidance that if Mr. Avery's new direct connection evidence survives Escalano, Naranjo, scrutiny, and has merit, the motive evidence found in the Bailey CD quote might become relevant to showing, in bracket, Bobby Dassey's motive and might bear on whether Dassey is or should have been a viable Denny suspect, end quote, emphasis added. Moreover, the Circuit Court failed to consider the motive evidence, although not conclusive, in conjunction with Mr. Avery's new evidence, which establishes a direct connection between Bobby and the crime. Mr. Avery offered his motive evidence in conjunction with evidence of Bobby's opportunity and direct connection to Miss Horbuck's murder and the framing of Mr. Avery. Evidence of motive that would be admissible against a third party, were that third party the defendant, is therefore admissible when offered by defendant in conjunction with evidence of that third party's opportunity and direct connection. Wilson. In rehashing the weight of Mr. Avery's prior evidence of motive contained on the Bailey CD, in which this court already assessed was not sufficient in and of itself, but could be relevant if Mr. Avery could also show Mr. Dassey's direct connection. Would you like me to read the footnote?
Yeah, why don't we? Yeah. Why don't we do that? I'll scroll down. Footnote 4.
Yep, this is number 4. This court stated, quote, the evidence, in bracket, Sawinski's evidence, close bracket, presented might supply the missing direct connection, emphasis added. And we scroll back up. The Circuit Court evaluated the CD evidence in isolation, contrary to this court's prior directive in remanding the case. See Wilson, in bracket, where the Wisconsin Supreme Court determined that the, quote, strength and proof, end quote, of one of the prongs may, quote, affect the evaluation of the other prongs, end quote. Here, Mr. Avery's powerful direct connection evidence certainly affects the evaluation of the other prongs because it provides evidence supporting all 3 prongs of the Denny test. For example, even if the motive for Miss Horbuck's murder was not sexual, as law enforcement believed, the Sawinski evidence offers evidence that the motive could have been a robbery. And I'll read footnote 5. Many things were missing from Miss Horbuck's RAV4 that should have been present in the vehicle, such as Miss Horbuck's purse, wallet, money, which she had been paid that day, driver's license, schedules, receipts, maps, Toyota master key, house key, and other items related to her activities with Auto Trader or her, quote, hustle shots. There has never been proof previously that a third party had possession of the vehicle which contained these items. Importantly, Miss Horbach's vehicle itself had been stolen. Go back up. Okay. The circuit court's finding that Mr. Avery had not established the, quote, motive element is at odds with Wisconsin's case law. Wisconsin cases that discuss the motive element of their Denny analysis show that the standard for fulfilling the motive element of Denny is not overly burdensome, especially when there is strong evidence of a third party's perpetrator's direct connection to the crime. For example, State versus Ramsey 273 is a case in which very weak evidence of motive against a third party was presented by the defendant. However, the appellate court found there was strong evidence of a direct connection and thus found it, quote, plausible reasons for the third party to commit the crime. In Ramsey, the victim was found stabbed at a home. The 911 caller told police that the victim had been staying at her sister's home to hide from the defendant. The defendant had been in a relationship with the victim for over 11 years, and they had 2 children together. They had a history of domestic violence. Officers found the defendant, and the defendant admitted stabbing the victim twice. The victim's best friend told police that the day before the stabbing, the victim told the defendant that she was going to leave him. After fingernail clippings from the victim revealed another man's DNA, the defendant brought forth a Denny motion, arguing that a potential third-party perpetrator, 1, was a convicted criminal, 2, lived near the crime scene, and 3, his DNA was present at the scene and is unexplained. The defendant alleged 2 possible motives for the third-party perpetrator: irrational rage and antisocial behavior and or sexual gratification. The defendant argued that it was possible that the third party had no rational motive. Thus, the defendant presented evidence of a general motive which was not directed at the particular victim. In Ramsey, the circuit court found that the defendant had failed to establish the third party's motive and denied the motion. However, the appellate court reversed the circuit court's ruling, stating, quote, we conclude that when considered under the applicable law regarding motive and with the opportunity evidence and the strong direct connection evidence, Ramsey has presented plausible reasons for, bracket, the third party, close bracket, to commit the crime. The appellate court found that, quote, under the totality of the circumstances, the evidence suggests a third-party perpetrator actually committed the crime, emphasizing that suggests is a rather broad term. Here, Mr. Avery has presented far more evidence that is even required to suggest that a third party actually committed the crime. The circuit court's failure to consider the Denny prongs in the aggregate and its erroneous imposition of a burden of substantial certainty on Mr. Avery's motive evidence results in a fatally flawed opinion on the law and the facts. Jack 61, can we get someone else to read?
Absolutely, Doc.
Yep.
Thank you very much for that. And
Oh, not at all.
Katie, you feel like reading some? You're a great reader.
Hey, my eyeballs are super dry tonight.
That's okay.
I'm sorry, I'm worthless.
That's okay. Sheree, would you like to read a little bit?
Sure.
Read as much or as little as you want, and just let me know.
Okay. Opportunity element of Denny. In regard to the opportunity element of Denny, the circuit court stated in its opinion that even if the defendant had met the burden with respect to the motive element of the Denny test, excuse me, he has not met the burden with respect to the element of opportunity under the same test. It's undisputed that Bobby was on the Avery family property when Miss Hallback was there and before and after she was reported missing. Normally, even proximity to the murder is sufficient to show opportunity. Excuse me. However, the circuit court improperly imposed a burden on Avery to prove that Bobby had the skills, contacts, tools, time, and or other means necessary to have committed the crime and staged the scene in order to satisfy the opportunity element of Denny. The circuit court cited State v. Wilson for its own finding that a Mr. Avery has to prove that the potential third party had the skills, contacts, tools, and or other means necessary to have committed the crime and staged the scene in the manner alleged. Excuse me. However, in reality, this principle came from the Kansas Court of Appeals case that the state cited in its response brief, State v. Kreider. Even if the principle from the Kansas case were to somehow apply to Wisconsin, the facts of Kreider are completely inopposite to those in Mr. Avery's case. In Kreider, the defendants proffered evidence of a potential third-party perpetrator consisted of alleging a potential motive for the victim's son-in-law to kill her, and that the son-in-law's wife would benefit from the inheritance, and that the son-in-law could have had the opportunity to get the defendant's hair from the headgear and blood from used bandages to later plant at the crime scene while staying there overnight because he worked as a first aid officer at the defendant's work. The court found that the evidence did not effectively connect the third party to the crime, stating this evidence is nothing more than mere speculation and conjecture and does not connect the third party to the crime, and therefore the district court did not err in excluding it. Rather than considering that this principle came from a Kansas case, not a Wisconsin one, the circuit court imposed a burden on Avery. I lost my place. On Mr. Avery to demonstrate that Bobby had the scientific knowledge to plant the evidence. The facts of Wilson are completely opposite to Mr. Avery's case. In Wilson, multiple eyewitnesses identified the defendant as a shooter. The defense attempted to argue that someone else was the shooter by proffering evidence of an alleged potential third-party perpetrator. However, the potential third-party perpetrator was completely unknown because the defense's theory was that a hitman was hired by the man in the car with the victim to kill the victim, and then the hitman shot the victim. The Wilson court found that there was no evidence showing that the man in the car with the victim had the opportunity to hire a hitman in the brief amount of time he was in the car with the victim before she was shot by someone else. The defense failed to present any evidence of contacts, influences, or finances used to hire a hitman to corroborate its hypothetical theory that the potential third-party perpetrator was some unidentified hitman. Thus, the Wilson court found that Wilson's proffer failed to demonstrate that these alleged assassins were anything but purely hypothetical people. Importantly, Wilson is not a case about planting evidence or framing. Wilson specifically stated that this type of theory only requires a showing of access to frame, stating the following: if the defense theory is that a third party framed the defendant, then the defense might show opportunity by demonstrating the third party's access to items supposedly used in the frame-up. However, the circuit court erroneously reasoned that pursuant to Wilson, Mr. Avery must prove that Bobby had the scientific knowledge to recognize the significance of each piece of forensic evidence supposedly planted by him, let alone establish that he had the skill to plant that evidence in a way that would stand up to scientific scrutiny by a third party. I lost my place. By professional crime scene analysts. This is not the standard for showing a third party framed the defendant. Evidence that a third party had access to the items used in the frame-up is sufficient pursuant to Wilson. Ultimately, the circuit court imposed upon Mr. Avery a standard for satisfying the opportunity element of Denny that has never before been applied in any Wisconsin case. State v. Valbrecht is a case which the evidence of a connection and motive carried the strength of the opportunity evidence. The trial court granted the defendant a new trial and the appellate court affirmed. Although the evidence of the third party's opportunity only theoretically put the third party in the geographic area of the murder victim, the appellate court focused on the strength of the evidence of motive and direct connection rather than imposing any higher burden to show opportunity, as the circuit court in Mr. Avery's case did. The facts of Valbrecht are similar to those in Mr. Avery's case, where in both cases the defendants were convicted based in large part on completely circumstantial evidence. In Valbrecht, the defendant was convicted of first-degree murder and first-degree sexual assault of a woman who had been shot in the back, was found in a wooded area, naked and hanging from a tree by tire chains. The defendant had been with the victim the day before she was reported missing. He told police that he was dropped off by her, but detectives spoke to several people who knew the defendant and were in the area where he claimed the victim dropped him off, and none of them saw the defendant in the area. Police interviewed a witness who identified the defendant as the person the witness saw near the area where the victim's body was found on the day she was reported missing. Further, the defendant's hairdresser told the police that the defendant talked to her about the murder investigation and told her that I didn't do it, and if I did, I don't remember doing it. A witness who lived near the area where the victim was found testified that he woke up and heard shots around 2:50 a.m. and the sounds of a car dragging, which then stopped. He heard it start up again 20 minutes later. His testimony was used to establish that the victim was murdered before 3:30 a.m., the time which the defendant estimated he had parted ways with the victim. 20 years after his conviction, the defendant filed a 97406 motion for a new trial based on newly discovered evidence of a third-party perpetrator who had been convicted of a similar killing only 6 weeks later. The new evidence stemmed from the post-trial discovery of police reports, including information that a search of the third party's residence uncovered a revolver and books involving rape, chains, and torture. Notes about the third party's statements to co-workers about tying girls up, abusing them, and getting rid of them, and statements to inmates that the third party liked to chain and burn women. The state took issue with the opportunity prong of Denny being satisfied, noting that the third party lived 30 miles away from where the victim was found and also had killed the other victim 30 miles away. It argued that opportunity evidence must be more than just the theoretical possibility of the third party committing the crime. However, the appellate court rejected this argument and found that the record reflects that the post-conviction court's determination as to opportunity was made in light of the evidence presented as to motive and direct connection. We agree with the defendant that facts give meaning to other facts and that the significance of the third party's opportunity to commit the crime depends on his alleged motive and direct connection. In Mr. Avery's case, the opportunity element had already been decided previously by the courts. According to Mr. Avery's trial court, Mr. Avery's trial defense counsel already established that Bobby had the opportunity to commit the murder of Miss Hallback because of his presence on the property at the time Miss Hallback was there. Moreover, Mr. Avery's new evidence could not present a better case for showing a third party's access and accordingly evidence of a frame-up. The Sawinski evidence greatly strengthens Mr. Avery's evidence that Bobby had the opportunity to commit Miss Hallback's murder because it shows that Bobby was in possession of Miss Hallback's vehicle where her murder likely occurred. He had access to Miss Hallback's vehicle and all the evidence used to convict Mr. Avery of her murder. If the defense theory is that a third party framed the defendant, then the defense might show opportunity by demonstrating the third party's access to the items supposedly used in the frame-up. Correctly applying Wilson, Mr. Avery has not only shown Mr. Dassey's opportunity because of his proximity to the murder, but also because he had access to the items used in the frame-up. The defense theory of a third party's involvement will guide the relevance analysis of opportunity evidence in a Denny case, State v. Wilson. It is not the circuit court's theory that guides this analysis. Rather than accepting this, the circuit court found that Bobby needed some kind of expert scientific knowledge to plant the evidence and that he had access to in the vehicle. However, there is no scientific knowledge necessary to know that planting someone else's blood in the vehicle of a woman that went missing would be incriminating. Common sense would suffice. The circuit court did not explain what special skills it took to shoot Miss Hallback in the head that Bobby lacked. All that was required was to pull the trigger. Bobby was a skilled deer hunter with a .22 rifle. He had obviously pulled many triggers. In terms of planting the evidence with the blood, the only skill that would be required is taking a wet sponge and removing Mr. Avery's blood from his sink and dripping 1 to 2 milliliters into the RAV4 and applying it to the dashboard with a household item such as a Q-tip. Mr. Avery told law enforcement in a recorded interview that his finger, which had been cut open prior to October 31st, 2005, re-bled on November 3rd, 2005, and dripped blood in his bathroom sink and on the bathroom floor. Mr. Avery told law enforcement and his trial defense counsel as he was leaving his property on November 3rd, 2005, and exiting onto Highway 147, he observed taillights of a vehicle close to his trailer. Mr. Avery told trial defense counsel he noticed the blood had been removed from his sink when he entered the bathroom early on the morning of November 4th, 2005. The bullet fragment found on Mr. Avery's property simply had to be rubbed in Ms. Hallback's blood or on her skin cells, both of which her murderer had access to before her body was burned. The court determined the state did not argue that this specific bullet entered Hallback's skull or killed her, and there were no bone fragments on the bullet. It is undisputed that there were bullets all over Mr. Avery's property from Rollie Johnson shooting gopher holes with his .22 rifle, as well as Jody Stokowski firing it. This was the gun that fired the bullet that was found on the Avery's garage floor with Ms. Hallback's DNA on it. No skill was required to plant the electronic devices in Mr. Avery's burn barrel. The fact that there were burn barrels at the Dassey property, 4 in total, one of which contained human bones, shows that the Dasseys, which includes Bobby, were proficient in burning material in the burn barrel. Part of the circuit court's interpretation of Mr. Avery's guilt is based on another factual error. Its belief that all Miss Halbach's bones were found in the Avery burn barrel. They were not. They were found in the Dassey burn barrel. Dr. Eisenberg claimed that when she opened the container of bones from the Dassey burn barrel, she got a waft of flammable liquid or fluid, but did not smell smell burned rubber from tires, which the state claimed was the accelerant Mr. Avery used. This evidence suggests Miss Halbach's body was burned in the Dassey burn barrel and dumped in Mr. Avery's fire pit. Common sense suggests that Mr. Avery would not have been planting evidence to incriminate himself. The circuit court erroneously stated that Mr. Avery argued that Bobby planted the key to the victim's RAV4 in Mr. Avery's trailer between November 3rd and November 5th. There was no such argument made. Bobby would have had the key when he planted Ms. Halbach's vehicle on November 5th because it is undisputed the RAV4 was locked when it was discovered. So whoever left the vehicle on the Avery property necessarily had the keys and locked the vehicle. Bobby had access to Mr. Avery's unlocked trailer from early Saturday morning, November 5th, until shortly before noon when the vehicle was located, and the Avery property was secured by law enforcement. Mr. Avery and his mother left for their Crivets cottage around early Saturday morning. According to the circuit court criteria, Mr. Avery was even less qualified to commit the murder than Bobby by way of comparison. In terms of his education, he was less educated than Bobby, never having graduated from high school. He was less skilled than Bobby because he never held a job because of his wrongful conviction, whereas Bobby was employed as a third shift worker at a furniture factory. During all the years Mr. Avery was incarcerated for his first wrongful conviction, Bobby had been honing his skills in stalking, hunting, killing, burning, and dismembering game. After misapplying Wilson, the circuit court erroneously presupposed that the forensic evidence against Mr. Avery stood up to scientific scrutiny in Mr. Avery's trial. Mr. Avery's defense team never presented the required experts to attack the scientific evidence. Mr. Avery, in his second post-conviction motion, presented voluminous evidence from numerous experts that the forensic evidence which was used to convict Mr. Avery was vulnerable to being discredited if the defense actually presented all the experts that the trial defense counsel failed to present, such as DNA, trace, blood, spatter, fire, forensic pathologists, and ballistics experts. This court determined certainly these conclusions tend to support Avery's general theory that he was framed, and their presentation may have been useful at trial, but concluded that Avery's experts had failed to show how its introduction at trial could reasonably have led to a different outcome. Now this court has a direct link between a third-party suspect and the forensic evidence. This court can consider Mr. Avery's forensic expert opinions in light of the identification of a specific third-party suspect in determining if this evidence could reasonably have led to a different outcome. For example, Mr. Avery's blood spatter expert described the blood pattern distribution in the vehicle as being inconsistent as coming from an active bleeder, as the state claimed. Knowing Bobby had access to Mr. Avery's sink with blood in it and how simple it would be to selectively drip the blood in the vehicle, this court could reconsider the blood spatter expert's affidavit. Mr. Avery's DNA expert described that in the controlled experiments he conducted with Mr. Avery holding the key for 12 minutes, there was 10 times less DNA deposited on the exemplar key than what was present from Mr. Avery on the vehicle key found in Mr. Avery's bedroom. The expert suggested that if the DNA on this key was enhanced, some personal item of Mr. Avery's was used for this purpose, such as a toothbrush or a cigarette butt. Mr. Avery previously presented an affidavit that he noticed his toothbrush was missing in the law enforcement photos taken from the bathroom in his trailer. In regard to the hood latch swab, Mr. Avery is not abandoning his theory that the illegally collected groin swabs taken from Mr. Avery were substituted for the hood latch swabs when they were delivered to the Wisconsin Crime Laboratory. However, for the purposes of demonstrating that Bobby had the skill necessary to plant DNA on both the hood latch and Miss Halbach's key, Mr. Avery asserts that Mr. Avery's toothbrush could have been rubbed on both. Bobby had access to the trailer where his toothbrush resided prior to disappearing. Could I take a break for a few seconds, please?
Absolutely. I'll read for a minute. We're
Okay.
nearing the end. Any comments before we continue on, guys? Duke, Doc, anyone? And I'd like to welcome Jay as well.
Hi, everybody. I'm still listening, but driving at the same time, so I've got you on hands-free.
That's okay. That's fine. Thanks for coming. Any comments, guys? Doc?
I just wanted to say it's very interesting reading this, how Kathleen Zellner has stayed away from any form of involvement by law enforcement in anything. And I believe that was done deliberately.
Absolutely agree.
Not necessarily. There's something she just said that leaves that door open.
You mean the groin swab?
Yeah.
Yep.
Correct.
Mm-hmm.
Yeah, but other than that, she's danced around it, but she's not made a direct accusation. And, we all understand why.
Mm-hmm.
Right? Yeah.
Yes.
Okay. Anything else, guys, before we continue on? Let's see here. We're on page 50, so we don't have too much further to go. Maybe I'll try to take us out. If everybody's ready.
Well, I just want to say, in fact, when she's talking about the hood latch, that Mr. Avery is not abandoning his theory that the groin swab was used on the hood latch, which can only inculpate law enforcement.
That's true because as many may or even may not know, the hood latch swabs were supplied by Calumet County. The crime lab did not take those swabs. They were given those swabs. I'm stating that correctly, right, guys? Doc, everyone? Everybody agree with that?
But the just going off what Susan said, that does include the potential for law enforcement to have been involved in some of the planting of the evidence. But the main thrust is a focus on Bobby Dassey because of having a witness in Tom Sawinski claiming that he saw Bobby Dassey in possession with Teresa Halbach's RAV4. So the main thrust of her argument is that because Bobby was in possession of Teresa's RAV4, he had the potential then to plant all the forensic evidence against Stephen. That's the main thrust of her argument.
For
Danny, her main focus is Danny. Yeah,
it's not to say that he did with 100% certainty. It's just to say that he could have.
Correct.
The potential's there, and it's ignored or discounted.
Exactly, and that's all she has to show.
Correct. Her main aim is to show an element of doubt. That's the important thing. Whether it occurred or not, I don't really think that's important at this stage, but to bring in an element of doubt. And her argument is, if this material was presented in 2007, would it have altered the outcome of the trial? That's her main thrust. what her
Right.
main argument is.
And Bobby they should have been able to use him as a Denny.
That's
Correct.
right.
Trial.
And they weren't allowed to.
No.
Yep.
No, and even Judge Angie, continued on in her as Zellner has went through here and stated what Judge Angie did. I think it's well, so far it seems to be pretty straightforward to me. I don't have too many arguments, I guess. So, okay, you ready to go?
Yeah.
All right.
Take it away.
Number four, direct connection element of Denny. No bright lights can be drawn as to what constitutes a third party's direct connection to a crime. Rather, circuit courts must assess the proffered evidence in conjunction with all other evidence to determine whether, under the totality of the circumstances, the evidence suggests that a third party perpetrator, underlined, actually committed the crime. State v. Wilson. Emphasis added. In its opinion, the circuit court argued, quote, the Sawinski affidavit taken as true for the purposes of this motion directly links Bobby to possession of the victim's vehicle. However, possession of the vehicle does not directly link Bobby to the homicide itself, end quote. Then the circuit court highlighted the fact that, quote, Mr. Sawinski's affidavit does not mention seeing Bobby with the key in the victim's car, end quote. It ignored the fact that when Ms. Halbach's vehicle was found by law enforcement and volunteer searchers, it was locked. Clearly, Bobby had the key to the vehicle. Further, the circuit court ignored that all the forensic evidence used to convict Avery was discovered after Bobby was seen moving Ms. Halbach's vehicle onto the Avery property. In State v. Wilson, the appellate court found a direct connection between the perpetrator of the murder and the fact that he had possession of the victim's vehicle several days after her murder. Specifically, the court explained. We agree with the state that brackets from all these circumstances under a common sense, non-technical approach, a reasonable police officer would have drawn the reasonable inference that both Williams and Armstead had been in possession of Brown's stolen car. There was probable cause to believe that both Williams and Armstead probably had committed a crime involving the murder victim's stolen car. State v. Williams. Emphasis added. Applying this common sense approach here, the Sawinski evidence provides the direct connection, parentheses, that is, Bobby being witnessed in possession of Miss Halbach's vehicle, in parentheses, to Bobby having committed the murder of Miss Halbach and planting the evidence to frame Mr. Avery. Rather than recognizing the significance of evidence that Bobby had possession of and thus access to Miss Halbach's vehicle, the circuit court required Mr. Sawinski to see Bobby in possession of the electronics inside Miss Halbach's vehicle. However, a reasonable inference can easily be made that because the electronics had not been found by law enforcement when Bobby was seen by Mr. Sawinski with Miss Halbach's vehicle, they were still inside the vehicle. Footnote 6. Mr. Avery realizes that this case existed 2 months before it was found not to have precedential value. However, it is noteworthy for employing a common sense approach that possession of a murder victim's stolen car means that thieves probably committed the murder. In State v. Knapp, vacated on other grounds, the Wisconsin Supreme Court found that in light of the Denny and Chambers hearsay evidence implicating a potential third party in the victim's murder was properly admitted because it established that the requisite, quote-unquote direct connection pursuant to Denny. In Knapp, the defendant was the last person seen with the victim as they went out together that night. During trial, the defendant sought to introduce evidence of other potential suspects, including the victim's husband, Bruner, let me scroll here, and the woman he was having an affair with, Mass, on the night that the victim was murdered. Specifically, the defense sought to introduce hearsay evidence through the testimony of a witness, Farrell, who was close friends with a man named Borhardt, whom Mass had lived with at the time but has since passed away. Though Farrell, the defense sought to introduce statements made to him by Borchardt regarding his observations of Mass's behavior right after the homicide and his observations of Bruner's truck at the Mass's residence after the murder. The Wisconsin Supreme Court found that the third party of the Denny analysis, the quote-unquote connection, was at issue. However, ultimately, it found that the evidence supplied the missing quote-unquote direct connection using the following reasoning. The evidence at issue in the Knapp case connects third parties, Bruner and Mass, to the crime in a number of ways. 1. It establishes that Bruner lied to investigators about his whereabouts at the time of the murder. 2. Mass was with Bruner at the time his wife was murdered, and Mass was observed a short time after Ms. Bruner's death carrying a paper bag and getting into Bruner's waiting truck. And 3. Most importantly, the evidence puts Bruner in Watertown in relative proximity to the location where the homicide occurred and near the time of the murder. Based upon that information, we hold that the Circuit Court correctly determined that the evidence established Bruner's motive, opportunity, and connection to the crime. Furthermore, we hold that the Circuit Court applied the proper legal standard and appropriately exercised its discretion in admitting this evidence under Denny. State v. Knapp. The court found that, based upon these three inferences listed above, the hearsay evidence established Bruner's connection to the crime and also fulfilled the quote-unquote motive and quote-unquote opportunity prongs of Denny, which it did not even dispute. If the same reasoning were applied to Mr. Avery's case, the Circuit Court would have found far stronger evidence of a direct connection to allow the defense to present Bobby as a potential third-party suspect pursuant to Denny. At bare minimum, the Sawinski evidence connects Bobby to Ms. Halbach's murder in all the same ways the hearsay evidence did to the third party in the Knapp case. 1. It establishes that Bobby lied to investigators about his whereabouts during the times relevant to determining Ms. Halbach's murder. Parentheses, noting, of course, the exact time of Ms. Halbach's murder is not known, in parentheses. 2. Like Mass, he was observed carrying a paper bag after the murder, which the Wisconsin Supreme Court found was material. Bobby was seen with the victim's vehicle after Ms. Halbach's murder. And 3. The evidence certainly put Bobby in close proximity to the location where the homicide is alleged to have occurred. And that combined with the evidence showing that Bobby, according to his own testimony, was one of the last people to see Ms. Halbach alive, would have satisfied Denny had the Circuit Court applied only the reasoning of Knapp. The Supreme Court of Wisconsin offers an illustration to exemplify what type of evidence can show a quote-unquote direct connection to a degree of certainty required by the legitimate tendency test to admit evidence regarding a, quote, third-party suspect, end quote, by illustration where it is shown that a third party or third person not only had the motive and the opportunity to commit the crime, but also was placed in such proximity to the crime as to show
Uh-oh. Think we may have lost Jack again. Can anyone hear me?
I can. Sounds like we lost that.
Okay. He'll probably be right back.
Maybe. Maybe his power went out for good.
I know he has a generator.
Oh, yeah.
Shall I go on reading or shall we wait a little bit?
You could go on reading, I think.
I think, Susan, if you go on reading, that's probably the best way because we don't know how long Jack's going to be out for. So I reckon continue.
Did he stop where it starts at State v. Volbrecht?
I think he was pretty close to the bottom of page 53, if I recall.
Okay. Yeah, I think you're right. Let's see. The Supreme Court of Wisconsin offers an illustration to exemplify what type of evidence can show a direct connection to a degree of certainty required by the legitimate tendency test to admit evidence regarding a third-party suspect. By illustration, where it is shown that a third person not only had the motive and opportunity to commit the crime, but also was placed in such proximity to the crimes as to show he may have been the guilty party. The evidence is admissible. State versus Knapp. Even if the circuit court's numerous factual errors were correct, and Brendan Dassey was, quote, directly linked by forensic evidence to this murder, end quote, and his confession was admissible evidence against Mr. Avery, this still does not allow the circuit court to dismiss the powerful evidence of a third party's direct connection to the murder. Overwhelming evidence against the defendant may not serve as the basis for excluding evidence of a third party's opportunity or direct connection to the crime. State v. Wilson. Quote, by evaluating the strength of only one party's evidence, no logical conclusion can be reached regarding the strength of contrary evidence offered by the other side to rebut or cast about, end quote. Holmes v. South Carolina. Conclusion. For the reasons stated herein, Mr. Avery respectfully requests that this court grant him one of the following alternative remedies. 1. Reverse the orders denying post-conviction relief and grant an evidentiary hearing. 2. Reverse the judgments of conviction and the orders denying post-conviction relief and remand for a new trial. And 3. Grant any other relief this court deems appropriate. Dated this 12th day of January, 2024. Wow.
Wow. That's right.
She makes a great case in my book. I mean, it's just all so logical. And it points out all of the lawful errors that Sakevich made. So it'll be interesting to see how this court replies to this. We know what the state will say in their reply. Bunch of, ridiculous arguments, as they always do. Mark said it, a precision dissection.
That's right.
Sorry. Jack
sorry,
is
guys.
back.
Yeah, I got bushwhacked again. Power flickered like 3 times. I don't know if you guys heard me say my fire may go out, and it did.
We didn't even hear that.
Oh my God, so irritating.
Welcome back.
Yeah.
Thank you very much.
Yeah.
So you guys
We
just
did.
stopped where I was.
We finished it. There was only maybe
Oh,
a page and a half left or something.
Oh, okay, good. Okay, great.
Wasn't much.
Well, yeah. I mean, I didn't get to hear that last part. I heard what you said about Mark said a precision dissection. Yeah.
Yeah.
Yeah, I have to agree. It cuts right to the point, and I think she established in many other rulings that she cited that Judge Angie made a lot of errors in her decision, completely ignoring a lot of previous decisions. So.
Yeah, and we knew that, right?
Yeah, that's right.
Yeah.
So let's see here. Mark had said something earlier too. This was a while back. This issue is principally about the due process and the like thereof, and of Stephen's right to post-conviction relief. Completely agree with that. Absolutely.
Mm-hmm.
What else we got? Any other commentary? Any takers on how long it's going to be for the state to respond, even given an extension time? Do you think they'll take it to the limit, or will they reply very quickly? No takers?
I would guess they would take it to the limit as far as they can. That's been their MO from the start.
Yeah.
Which makes it so frustrating. But you're right. I do believe that the Court of Appeals is the whole process is faster than the circuit court. It seems to me.
Seems to be, yeah. Yeah, I definitely agree with that. Okay.
She didn't have a lot to say about
Baresh?
Baresh, yeah.
Yes. Yep. She never I don't think she mentioned Baresh.
She did.
Just one. She did early on. Early in the document she did, but
as in expand on what he observed.
Yeah.
Yeah, but it was very little.
Yes, she did not have his affidavit or she just described that he had seen he was sure it wasn't Stephen Avery driving the car. But other than that, said he saw him on 147 and Q, and then the vehicle turned, I think, left after he had passed him, something like that.
Yeah. I'm just trying to look through some comments here. We got a pretty good crowd, and we didn't. Normally we say hello to everybody. We didn't do it this time because I was late anyway. And but that's not to say that we don't thank everybody for coming and listening to us go through this. I see Becca and there's Sheila Hawkins and Lisa, Gloria. There's so many regular people, and I think we have some new folks listening in. There's Hugh Frazier. There's Barb.
Barb is with us as well.
Yep. Amy. So we really appreciate Mr. President. We really appreciate everybody coming and listening and going through this process. Again, for those that don't really know, after the VLCD was given, after they took the Dassey computer and they did the examination. The VLCD was given to Fassbender on May the 11th, 2006. So they had access to it, and I'm sure they went through it because his report was basically a bunch of, I'm just guessing, a bunch of PDF files or something of that nature that was just easy to open and to go through all the searches and imagery and so forth that he had found. Nonetheless, they went after Brendan, and to me, it was all set up and planned for Kaczynski and O'Kelly. Went after Brendan on May the 12th. O'Kelly had him isolated and really put the screws to Brendan. I mean, anyone that watches that video, I think O'Dog got it. It's horrible what he did to that kid. And then, of course, again, you have to read the January 2010 hearings to understand that this was a planned event. I'm sure of it, to isolate Brendan on that day, to force him into a plea deal. And they are the ones that arranged for Brendan to be interviewed the next day on May 13th. Kratz approved it. Of course, Kaczynski eventually got removed and he got hammered a little bit. I think he should have lost his bar card forever for allowing that. But Kratz didn't get anything at all. And he's the lead prosecutor. He could have said, no, the lawyer has to be there, because he knew Brendan had a lawyer. And he had to know Brendan wasn't savvy enough to see what was going on. No way. I mean, he had to know, but he allowed it. Nothing happens to Kratz. Anyway, moving forward, I think it was about a month later. I know it was in June. I don't remember the exact date, but it was about a month later is when Kratz went and filed the third-party Denny restrictions in June of 2006. So this whole thing, this whole thing, I do think that, and I'm not saying that Bobby or anyone else did anything. I'm just saying that in the course of due process, this was all, to me, it was all just completely, it was, to me, an abuse, because even going all the way through before we got today's stuff, I could see it. Again, I'm not saying that Bobby did anything. I'm not saying anyone else did anything. I'm just saying that it should have been allowed, given especially what we know now with Sawinski and his statement. And if he hadn't made that if he hadn't made that call that we got in early 2022 and those newly released batch of calls that we got from Manitowoc, we would have never even had that. That was buried. Unfortunately, we don't have the second half of that call, but there's nothing we can do about that. Anyway.
The first half is, what's the word?
Well, it gives it integrity. It gives his affidavit integrity.
Exactly.
Some backing.
Exactly.
A phone bill or something else would have been even better, but it doesn't matter. His girlfriend at the time, she swore that was his voice under her own affidavit. So that's even more proof, and it was ignored by Judge Angie. And I have to wonder, again, I'm not a lawyer, and I just have to wonder how much or what was said that she would remove herself from this case. She's been involved with this case for years, a decade at least, going back to, gosh, I'd have to look at the record. But I know it going back at least 2013. I know Avery filed his pro se motion 2012, 2013, somewhere in that neighborhood.
Was she in that position when she, you said it was around the time he filed his post-conviction.
That's right. It's pro se.
When she was delayed in dismissing the Hallback lawsuit.
Yep, she was involved in the civil suit. Yep, she was involved in that. So you have to wonder, coming this far and for this long, and as many rulings as she's made concerning this, why she would withdraw. I question that. Anyone got any comments about that? Doc, anyone?
Well, potentially it's gotten to a state where it's become, in my opinion, really ridiculous. The reply that Kathleen Zellner just wrote now and filed, that's a very, very powerful, very poignant response, basically highlighting all the errors that Judge Angie had made in her response. And the new judge looking at this really has to consider all the points that Kathleen Zellner has raised. And I do want to emphasize, and I'm glad you brought it up, Jack, we're not blaming Bobby Dassey for having committed any wrongdoing in this. That's very important. Kathleen Zellner, her approach is to get a new trial for her client, which is Stephen Avery. Yep. And she's actually following the lineage outlined by the state. Because remember, the state was saying back in some of her early filings, oh, look, if you want to claim Bobby Dassey as being a Denny suspect, you've got to make your presentation more stronger. You've got to have a direct connection of Bobby Dassey to the crime. And hence, you've got the affidavit of Tom Sawinski. Now, it's going to be pretty obvious, in my opinion, and I'll be interested to hear your comments. There's absolutely no doubt that the state is going to go after the credibility of Tom Sawinski, Tom Barash. They're going to directly go after both of them. What disturbed me, in a way, my final comment here, guys, is that Judge Angie was almost convinced and even stated that if Tom Sawinski and Barash were correct in that Bobby Dassey was in possession of Teresa's vehicle, the state didn't seem to care because not enough direct evidence of Bobby Dassey having Teresa's keys or electronics was enough to establish a direct connection with those items. Do you know what I mean?
Ridiculous.
So I know exactly what it is. It's completely ridiculous. I think we all agreed back then, Doc.
Because 3 points. Because no witness said, I saw Bobby searching pornography for these items. There's no witness. 2, there's no witness for Bobby holding Teresa's keys in his hands. And 3, there's no witness showing Bobby Dassey in possession of Teresa's electronics. Judge Angie says, oh, well, too bad if he had possession of the vehicle. That's not enough, which is, Kathleen Zellner saying, hey, wait a minute, you can't get any more of a direct connection than Bobby being in possession of the victim's vehicle on the very same day that it's found by Pam of God. So it's going to be a very interesting argument what the new judge says. But I do want to emphasize, the foul play team, and we'll say it again tomorrow, is not saying that Bobby committed any of these offenses. Remember, Kathleen Zellner has to look at what her strongest elements of the case are, and that's why she's presented Tom Sawinski's, Tom Barash's affidavit to establish a direct connection. So that's important to highlight. Thank you.
Yeah, Doc, I'll just say that. May I just for a second that
please.
This new judge is not going to see any of this unless the appeals court sends it back down.
Right. Okay.
Yeah. Right now we're looking at the appeals court to rule on this.
Right. Well, and to add to what Doc said and what you just said, remember that, and she said it in this brief, she's basically doing what the Court of Appeals told her she had to do.
Yep. They directed her in this. Exactly.
That's exactly right. She filed a third 97406 motion. She dropped the other ones.
Mm-hmm.
So, even talking about, the first one, that of course, actually, it really should be considered the second one, because she closed Avery's pro se instead of amending it, which she should have done originally. She should have just sent in an amended 974 and just continued on. It is what it is. It's gone now. All the scientific evidence that the experts that she got, when I talked to those on the state advocate side, the stuff is just considered, or it's not considered. It's not part of the case, but in truth, it really is. Just because they came along and said it's procedurally barred doesn't mean it's not true. And that gets discounted a lot. It's just that it can't, at this point in time, it can't be included. However, if a hearing is granted and then a new trial is ordered, all of that, everything comes in. Everything.
Yes.
It's
Yes.
opened back up. You start over.
Yes.
And,
Yep.
and that's been her goal.
Yeah, I think that's all of our goal.
Yeah,
is to
absolutely.
be able to get a fair trial.
Yeah, and
That's
that brings
everything.
about, I think that brings about another potential problem at this point. I mean, we're so involved, maybe we can't quite see it like somebody that, is involved, but, more on the periphery. Is there any, I mean, you guys can think about this and answer it. I've thought about it. I won't say at length, but a lot. Could Stephen and then potentially Brendan get a fair trial in Wisconsin or anywhere in the United States?
Well, let's hope that there's someone in Wisconsin that truly cares about justice, that truly cares about the system and the way it's supposed to work, that cares about the laws as they are written and to follow them. For God's sake, it's pretty damn simple. Just follow the laws that you've made. It's just like the
and
skirt.
I'd be willing.
Sorry, dude.
I'd be willing to bet. Oh, you're fine. I'd be willing to bet a lot of money that if Kathleen Zellner got this to a new trial and got herself in the courtroom and certain defendants, certain witnesses up on the stand, it wouldn't matter how potentially corrupt anyone in that courtroom was. There'd be no doubt these guys would be walking home and free.
Mark Codnott says if a new trial is ordered, Stephen will be entitled to bail.
Yeah. Well, again, I mean, it just opens up
Can't see
an
that
endless
happening.
amount of possibilities. I mean, think of the certain people that we've always wanted and wondered why they didn't testify before. I mean, you put Jason Jost up there, right?
Yep.
Could you imagine Kathleen Zellner cross-examining Cherie Culhane? Could you imagine that? I mean, she would absolutely demolish her. So, could he get a fair trial? I don't know, but would Kathleen win anyways? Yeah, I think so.
Kathleen demolished Elaine Taylor and her deposition for the Holtzclaw case. She knew the science better than Elaine Taylor did. It was really fun to listen to and watch.
Yes, I agree. She was great in those depositions.
Could Stephen make bail? If I wonder what they would set it at.
Boy, I don't know.
I mean, some judges do really petty things. It's crazy.
Look how hard this wasn't a new trial, but for Brendan, how hard Schimmel and his compatriots fought to keep Brendan in, So imagine they would go even further with Stephen, but hopefully things will change by then. Wouldn't it be nice?
It would be nice.
Yeah.
Mark says,
Mark makes a good. Yeah. I was just going to read that. Go ahead.
Don't forget how close the jury vote. Oh, it went away. Let's see. Let me get back.
How close the jury vote was the first time without all the information we have now.
Good point.
Yeah.
Yeah. Yeah. But yeah, Brendan was close to getting out while they decided, Becca, while they appealed, the state appealed. But he didn't he wasn't getting a new trial. So, but I agree. I mean, it's similar. He should have definitely been let out while they were deciding his appeal.
And it happened again.
Oh dear.
Wouldn't that be brutal to be out on bail pending your new trial and then have to go back in?
Yeah, I've seen a lot of cases of that happening, actually. Awful.
Man,
Oh yeah.
those would be some hard steps.
Yeah. I've been watching
Okay.
that Guilty or Innocent. It's a really good show on A&E.
I've watched some of those. It's been a while. Yeah, it really
Yeah,
is a good show.
There's 5 seasons of that. I didn't realize there were so many seasons.
Oh wow, I did not either.
Yeah.
Okay. Any other comments? I see. I mean, I got knocked offline, but I see there's been quite a bit of conversation. Yeah, Becca says Brendan was packed up and ready to go.
Ugh.
Yep, I remember that. That was brutal.
So cruel.
That was
That
So
was
brutal.
brutal. Gave away his stuff. Gave away his ice cream or something, didn't he?
Everything.
Yeah,
I guess
he
that
gave
he
away
wasn't going to take.
everything.
Yep.
Yeah.
So I guess we'll have to hear from a lawyer. But I do think that the state has 30 days to reply, and they can ask for an extension. And I think it's 10 days that they could be granted. But I could be wrong about that. But I think that's right, if I'm remembering correctly. If anybody has any, does that sound right, Cherie? Is Cherie still here?
I'm not an expert on it, but it does sound right to me too. But Travis would be a good one to ask.
Yeah, or Tracy. I'd love to get Tracy's take on the brief.
Well, I do think that what we talked about earlier, that Judge Angie was requiring somebody to have seen the key and the electronics in possession. I think that's a bridge too far, because if somebody says, "Hey, I saw this person with the, missing person, murdered victim's car," I think that predisposes that those things would be in the car.
Well, yeah. I mean, it's just logical. It was just the dumbest argument. Their arguments just, I don't even want to call them weak. They're ridiculous.
They are completely unreasonable.
Estimation. Yeah.
Completely unreasonable. Yeah, I agree with Mark. I was talking about what Kratz or what Kaczynski and O'Kelly had done earlier, and one can't forget that if you look at the material that and I'm sure we don't have everything, but we have enough that showed the connection between Kaczynski, O'Kelly, Kratz, Uyghur and Fassbender. They got copied on everything. Their goal was to force Brendan into this plea deal and gather evidence against Avery. That's what they did. That was their goal. It's so clear. So they colluded with the state. That gave Brendan and actually worked against him. They can work together. It was like having, two sets of prosecutors and investigators working against him to force him into a plea extortion deal. That's what I call it.
Mm.
It was straight extortion.
Really, if you look at it from the angle that maybe Angie did us a big favor by doing all of those ridiculous things and kind of forcing the courts to look at it from a legal perspective. All the basically the law she went against, how she totally misinterpreted everything. by sending it to the appeals court, and if they do grant an evidentiary hearing, we now have a new judge. I understand that he has been a defense attorney in the past. I think he's been on both sides. I think somebody said he was with the Innocence Project. I don't know for sure.
Which
But,
one?
The new judge
Oh,
in the circuit court.
gotcha.
I forget his name. So possibly, it all might come around to where, by her being so blatantly incorrect in her ruling,
Yeah.
and if she had granted an evidentiary hearing, we know what Sakevich would have done. She would have just denied everything anyway. But here we have somebody new who may actually care about the law. So we'll see.
Yeah, I mean, just looking back at at her rulings, and she ruled so quickly, and just declared everything procedurally barred at the time, and Zellner was still in conversation with Fallon. Of course, I don't trust him as far as I can throw my house. I just don't. He's so good at undermining and getting around the state statutes and explaining away these different things. The giving away the cremains. The missing evidence is just the evidence has gone missing, used up by the lab, the Crown lab. Evidence that was stated by Harrington is found. The blunt and bloody instrument, that's still being looked at. I know one member of the community has in contact with the DOJ to get an answer to that, and it's still, that started right after Sunshine Christina got that unfiled warrant. That question was posed to the DOJ. What the hell is going on here? What happened to this blunt, bloody instrument that was never declared or turned in?
Yeah.
Never even never tested for anything. Where's it at? To me, that's a pretty big deal, and it shows some potential weirdness going on in the state crime lab, in my opinion. It's just an opinion. I can't prove any of it because I don't have my hands on it. Don't have photographs of it. I don't have anything other than the statement in that unfiled warrant. And to me, there's just no way that Wiegert would pen a sworn statement without it being true. I can't get around that, and I'd like to be able to.
I'm just trying to insert some hope here.
Well, absolutely.
I think there is some hope.
Well, and we can't forget that the Wisconsin Supreme Court has politically changed, and since August of last year, that could potentially make a difference. I don't know that it will. I don't. But I think there's that potential. Because before, I don't remember which filing it was, but they refused to accept. The Supreme Court of Wisconsin refused to accept or hear any part of the case, whichever one it was, or whichever filing it was. A lot of good commentary going on. If Brendan, without Brendan's part in this, the state's case is severely weakened, in my opinion. I think if he was pardoned, that would certainly, that changes the flavor, but if it was something done legally in trial, and then his case was, dismissed or whatever, and he got out, that really hurts the state's case, and they know it. I think Kratz knew he had to have Brendan. Back in the day, he had to have some kind of connection, and I don't care what they say, they knew very early on that Brendan was there. And if you listen to the phone calls, Brendan was also there on the night of the 30th. October 30th. It's in the phone call. He's talking
He
to
was. They were in the garage.
They were
Yeah.
in the garage on the 30th.
Yep.
So anyway, hey, I did want to let's see, what did Mark say here? Stephen's case could end up as a habeas case in the federal court if the state's courts don't deliver on his post-conviction entitlements. That's true. It's hard to say, whatever the Court of Appeals does, what Kathleen's next steps would be. It may be to go federal. I guess it would depend on the whatever decisions that the Court of Appeals comes up with, right?
Absolutely. And if they were to affirm the circuit court's decision, I think they'd have a pretty good case for habeas.
Yep, I agree. Hey, I did want to welcome, this was a while back, Ruth Robinson is a new Valplay member. We appreciate the support. Thank you very much. And, well, all of our other supporters as well. So, okay. Any other comments, guys? We've been here for about 3 hours, including my several power flickers and outages. Doc, Duke, ladies, Jay, anyone have anything else to say?
I'd just like to say, I think Kathleen has a better argument than ever right now, with the way that Angie answered the last, her prior decision on this. I think
I agree.
it's stronger than I've ever seen.
Yep, I have to agree. She's put forth
Yeah.
a great argument. She's laid it out reasonably, in my opinion. I don't think there's anything unreasonable about it at all. She's cited several cases that tend to back it up to me.
Yeah, I
All right.
agree. She's really put, she really told the whole story again. I mean, pointed everything out. It's very detailed. Schooling them on the law, too.
Yep, I agree.
Travis said in way back in her first one, I think it was, on this third party perpetrator theory that State v. Wilson would be key, and it seems like we heard that quite a bit, that case in there. So proving Travis right.
Yep. Travis knows his stuff. Well, I'm a bit encouraged myself. I'm going to hang on to that.
Well, I always have hope that, reasonable people will apply the law reasonably and look at all the errors. Taking a quote from Convicting Murder Vast Mender says, well, mistakes were made. Yeah, there were a lot of mistakes made. I look at this case, just one glaring one that, just another one that completely gets ignored. Think about when this alleged incident happened on November 8th. What does Sturdivant do? Now, he's a state agent. What does he do? He goes over to Barb's house, gets a rake, brings it back to the fire pit, and starts raking with her rake. Leaves it at the scene. I ain't going to call it a crime scene. Leaves it at the scene. And then they collect it as evidence. A piece of, or a tool.
Crazy.
That's Sturdivant. Right. I mean,
and used it at trial.
And used it at trial. Yeah, and used it at trial. That's right. It's crazy.
Mark says Stephen is very happy with this filing from his lawyer. I would imagine.
Oh, I would bet he is. Absolutely. I'd have to agree with that, Mark. I'm sure he's very happy with it. Because the goal, again, is to get a hearing. And one never knows what can happen at a hearing. That's the jack in the box and where it can lead.
Absolutely. Yep.
All right.
Especially when you get Zellner.
That's right. Yeah, she's really good. All right, before we go too much longer, let's go around the room right quick. Let's get final thoughts, and we're going to get out of here. So first up, Doc.
First of all, thank you so much, Jack61, for putting this on at short notice. Yeah, look, very, very interesting. I agree with Susan. It does bring in a lot of hope. And again, I'd like to let everyone know that tomorrow, with the Reading with the Crew series, the new chapter that we'll be doing is looking at exactly this material. And you betcha we're going to be deep diving. So, yeah, please join us tomorrow for the new podcast series. Thank you again, Jack61, and the team.
Yeah, thank you too, Doc. I got all the material you guys have put together and just read through some of it. Oh boy. It's going to be a doozy, is all I got to say. And, you know, this is the 50-year anniversary release of Farrak's book and his added material. It's going to be very interesting. And, you know, if you're interested in, I mean, Farrak to me is a really good investigative reporter. I really wish he would just write a second edition. Maybe he will at some point. I don't know. And I also wanted to, before I forget, and I will forget if I don't say it now, also wanted to direct everyone that's interested in the case to the defense diaries. I mean, they cover a lot of cases. These are two defense lawyers that they're not taking sides. They're going through it piece by piece and stating their opinion on the various things that they see. And they've been really, really critical of the COA investigative report. They were from the beginning because, you know, it's written in the narrative and it's entered that way. We don't see the actual police report. It's a generated report in the narrative telling a story.
I've been catching up on that today. Yeah, they're doing a great job.
They really are. And, you know, we want to thank them for mentioning us and others as well, you know, for them being able to get material and documents.
Involving the community a bit, yeah.
That's right. And that's great. That's fantastic. But I can't say enough. They're covering other cases, the Delphi case and some other ones as well. They're really good. And no matter which side of the coin, I appreciate their taking their time and giving it the diligence that it deserves. So I wanted to give them a quick shout out. Anyway, moving on. Katie, final thoughts? Oh, go ahead.
I was just going to say, I just think they have no idea how long it's going to take them.
No, and I did ask a question in the Facebook group. I hadn't gotten an answer. They went through the Manitowoc summary report. They're going through the COA report, and I did ask if they were going to go through what DOJ reports that are available that we have. But I didn't get a reply on Facebook, so I'm not sure if they're going to cover those or not. Maybe I'll ask it on Twitter as well, or in one of their YouTube lives. They do go live and talk about the different cases. So maybe I'll ask it there.
Bob Mata and his wife.
Yeah.
I was going to say probably Bob is wanting to go through the DOJ, and Ellie's like, really? Because she's trying to like not make it as long. At least that's the feeling I get.
I think that really if they want to get at least as much full impact as possible, they really have to go through the DOJ, the DCI reports. If they avoid those,
sure,
they're missing a huge amount of material.
Bob and Allie Mata,
yeah, there you go.
There's Travis. Yeah. Hey, Travis.
Hey, Travis. Yeah, there you go, Bob and Allie. Yeah.
Have you read the brief, Travis? What's your opinion, if you have?
Yeah, well, he's typing that out. If he wants to give his comments, we can get them up. Well, otherwise, we'll move on and get Kay's final comments.
Well, just thanks for bringing this to us today on the day that it was released. It's good to read it. Looking forward to the content tomorrow on Foul Play and see what Doc has for us, and Neverly, I guess.
Yeah, Neverly's under the weather, so I'm not sure she's going to make it. Yeah, she's not feeling well, so
Yeah.
And I'm sure
Anyway,
she's going to make it. Yeah.
yeah. So good night.
Thank you, Kay. Thank you so much. And Cherie, final thoughts.
Just thank you for getting it on so quickly. It was definitely interesting and encouraging to me.
Absolutely. Thank you, Cherie. Duke.
Yeah, it was great to read through it, and I'll keep this brief. Kathleen's job at this point is to get an evidentiary hearing, and she outlined it as well. But I felt from the get-go that Judge Angie ruled as if she was ruling on the evidentiary hearing and not for one. So I think her points are clear, and common sense should prevail here.
Yep, I agree. Thank you, Doc. I totally agree with that. JD, final thoughts.
I just think she worded the actual document very well. I think it should be received by the courts of appeal, and they should act appropriately and get this out of the way. And I would just like to say thank you to everybody who read. I listened for 3 hours driving home, so I'm now home. So thank you, everyone, for sitting in the journey with me.
Thanks, Jay. Thanks for jumping on with us. Really appreciate that. Susan, final thoughts.
I just wanted to say that Travis said he hasn't had a chance yet. He tried to get over here, but he said
gonna put that on screen.
He'll read it and get some comments back to you, Jack.
Yep.
But yeah, I'll say once again, I'm encouraged more than I ever have been that some common sense might take over here. Fingers crossed. Everybody, you have a great night. Stay warm. I know it's cold pretty much everywhere. So take care.
Yep. Thank you, Susan. And my final thoughts are along the lines of everyone else. I guess I'm one of those people that has the cup half full all the time. I'm a optimist. I've been that way, I guess, pretty much my entire adult, late teenage years. I like to look at things in a manner of hope. That's just me. Not everybody thinks that way, and I completely understand. And thank you, Travis. If you read through it, it's a little over 50 pages. It's a pretty easy read, actually, of a lot of the filings that we've seen from both sides. I think that Kathleen is looking at this from a standpoint of reasonableness. I guess that's the bottom line of how this can apply to someone's rights as a defendant, going all the way back. So, and the steps
and how Judge Angie.
Yep, that's right. Ruled on everything.
How she did treat it as ruling on an evidentiary hearing versus.
That's right.
Deciding whether or not it needed one. Yeah.
That's right. Yeah, Kathleen did go through that, early in the brief. She talked about that. So.
Yep. What Duke
looking
just
forward.
Said.
Yep, I'm definitely looking forward to tomorrow and everybody's thoughts. It's going to be I'll just say it for Doc. It's going to be a ripper. What the new material. I know a lot of people have read what's in FRAC's new release, but a lot of people haven't. So it's going to be. I think it's going to be very interesting. Sunday for the open mic, it's been several months since we've read any of the 2005 depositions. We stopped because of Cam and got some other things that were going on, but I want to finish those as quickly as we can this year and get them out of the way. For those that are interested in the 2005 depositions, they don't really understand the significance. I think I do. I certainly don't know everything, but there's a lot of people that don't really understand a lot of the events that went on in 2005 and how they could and probably did affect the state in what they did. the events, steps that they took. I personally think that when Avery filed the lawsuit, the target went square on his forehead. I'm sure of that. I mean, we were talking about a multi-million-dollar lawsuit. Certainly he wouldn't have got that much, I'm sure, if it had went forward, settled out of court or whatever. But it was bad. It was bad. Duke?
Yeah, and if convicting taught us anything, it's that the past matters, right?
Yep.
And so that's why those depositions are great, because it gives us insight into the past where, like convicting tried to lay out this hypothesis of, a pathway to hell, essentially, that Stephen went down. There's a history of corruption. There's a history of wrongful convictions, and that needs to be considered.
Yeah, I would say malfeasance on the part of certain people. That's what I see. There's still a lot of things we can't get. They get denied or excuses given, delays, don't have it, corrupted this, corrupted that, can't, so your request is denied. And to me, at this point in stage, if the case is that strong, just release us, let us see it, let us, the public, John Q. public, have our look at it, right, wrong, or indifferent, no matter which way the case goes. All right, with that, I'm going to get us out of here, and thank everyone that's come in the live chat and commented, and talked about. I'm sure there's going to be more questions as times move forward. And with that, I'm going to say, join us tomorrow and Sunday, and this has been a Foul Play production.